So let's start lesson number 13, law relating to registration of documents and also immovable property. What property? Immovable property. Let's start. So registration of document. What of documents? Registration of documents. What is registration of document? Why do we need registration of document? It becomes more authentic and also it serves as a what? Evidence. So registration means recording the content of an instrument or a document with whom register for the purpose of what? Preserving the copies of the document. It is called as what? Registration. First of all, what do we register? Contents of a document. Content of what? With whom you register? Sub-register office. Why do we register? To preserve the copies of that or the contents of the document. It is called as what? Registration. Called as what? So we have a law called as Registration Act. Which act? Registration Act mandate the registration of few documents. And there are few documents where the registration is what? Optional. Registration is what? Optional. So let's discuss the registration of which document is mandatory and registration of which document is optional and how to get the document registered and what is the remedy available or what is the procedure to be followed to challenge or to challenge the rejection of application for registration. Okay? So let's start. First of all, what is registration? What is registration? Recording the contents of a document with what officer? Registering officer and preservation of the copies of the original document. What document? That is called as what? Registration. Called as what? What is registration? Recording the contents of the document with what officer? Registering officer. For what purpose? Preservation of the copies of the original document. That is called as what? Registration. Section number 17. Bolo section number what? 17 deals with documents which the registration of which is what? Compulsory. What is compulsory? Registration is compulsory. What are they? What is the first one? Instrument of gift of what property? Immovable property. Everybody, what is the first one? Instrument of instrument of gift of what property? Immovable property. What is compulsory? Registration is compulsory. With registration, a gift of immovable property will not take effect. Yeah. So what is the first document whose registration is mandatory? Gift of what property? Immovable property. What property? Immovable property. Next one, non-testamentary instrument. You know the difference between testamentary instrument and non-testamentary instrument. Testamentary instrument means the instrument which takes effect after death of a person. What is non-testamentary instrument? Before the death of the person. So non-testamentary instrument means the instrument which takes effect during the life of the parties. So any non-testamentary instrument, what instrument? Non-testamentary instrument which CD illa RTI. Remember CD illa RTI. What is C? Creates, destroys, or extinguishes, or limits, or assigns any right or a title or interest. Bolo? Which creates. If a non-testamentary instrument either it what? Creates or declares or extinguishes or limits or assigns any right or a title or interest to the value of how much? 100 and above. How much? 100 and above. In what property? Immovable property. What property? Then what is compulsory? Registration is compulsory. Clear with this? What is the first one? Gift of any document, gift of what property? Immovable property. Next one, non-testamentary instrument that creates CD illa RTI of the value of how much? 100 and above. In what property? Immovable property. Second one is done. Third one, non-testamentary instrument. Bolo what instrument? Non-testamentary instrument which acknowledges, which what? Acknowledges the receipt or the payment. Receipt or what? Of any consideration. Of what consideration? Any consideration. An account of what? CD illa RTI. CD illa. If I have received any consideration for the sale of property, let's say I have received 10 crore rupees or 1 crore rupees or whatever the amount it might be on a immovable property. What property? For sale of immovable property, is it required to be registered? Yes. The third document, non-testamentary instrument that acknowledges the receipt or payment of consideration on account of CDL RTI of how much? 100 and above. In what property? Immovable property. Third one, sorry, fourth one, lease of immovable property. Lease of what property? From year to year, means with auto renewal from year on year basis. What basis? Year on year basis. Or a lease exceeding a term of how many year? 1 year. How many year? Or a reserving a what rent? Yearly rent. What rent? So these are the three types of leases whose registration is compulsory. First one, year on year. Second one, reserving the yearly rent or for more than how many year? 1 year. What is compulsory? Registration is compulsory. Next one, non-testamentary instrument. What instrument? Transferring or assigning a decree or an award of a tribunal where the decree or what? Award creates, that is CDL RTI of how much? 100 and above. Of what property? Immovable property. What property? These are the five documents, the registration of which is mandatory as per section number 17. Tell me, what is the first one? Gift of immovable property. Second one, non-testamentary instrument that either creates, declares, extinguishes, limits, assigns a right or a title or interest of 100 and above. In what property? Immovable property. Again, non-testamentary instrument that acknowledges the receipt or payment of consideration on account of CDL RTI. What is CDL RTI? Creates, declares, extinguishes, limits, assigns, right, title, or interest. So the how much value? 100 and above. Fourth one, lease. What type of lease required to be registered? More than 1 year, year on year basis, or reserving a yearly rent. That where the rent is payable on a yearly basis. What basis? Yearly basis. Clear with this? Next, we have registration of non-testamentary instruments are subject to what exception? Following exception. The following non-testamentary instruments are not required to be registered. Not required to be what? What are those non-testamentary instruments whose registration is not required? What is the first one? Composition deed. That is nothing but compromise deed. Generally, the bank and the borrower or the debtor makes a compromise deed. Is it required to be registered? No. Composition deed. Below what deed? Composition deed is an exception to the requirement of registration of non-testamentary instrument. Second one, instrument with respect to what company? Shares in the joint stock company. What company? One more thing, debentures issued by the company, then any endorsement upon the what? Or transfer of any debentures. First one, shares in joint stock company, debentures issued by the company, transfer of any debentures, or document creating. Document what? A right to obtain another document. What document? Another document. What document? If there is a document to giving a right to obtain one more document. So I am entering into an agreement with you where you have made a promise that you will execute the sale deed. What deed? On the payment of full consideration. Is this agreement required to be registered? No, not required to be registered. Which one is required to be registered? Sale deed. What deed? An agreement to obtain one more agreement. Is it required to be registered? No, not required to be registered. Next one. Decree or order of a court. Decree or what? Order of a court. Is it required to be registered? No. What if I want to transfer the decree? Is it required to be registered? When? If it deals with a immovable property, a value of how much? 100 and above. 100 and what? Above. Next one, grant of what property? Immovable property. By whom? Government. Not required to be registered. Instrument of partition by whom? Revenue officer. What officer? Is it required to be registered? Not required to be registered. Not required to be registered. Document with respect to land improvement loans. What loans? Are agricultural loans. What loans? Agricultural loan. Is it required to be registered or not required to be registered? Not required to be registered. Next one, orders under the what? Charitable endowments. Assigning a property to the temple. Is it required to be registered? No. Next one, endorsement on the mortgage deed. What deed? Acknowledging the receipt of what? payment. And certificate of sale from what auction? Public auction. If government is selling a property and if anyone buys that property in the auction, is it required to be registered? No. So these are the non-testamentary instruments whose registration is not mandatory. Whose registration is what? Not mandatory. Are you guys clear with this? Yes or no? Then we have these documents of whose registration is optional. If you have read section number 17, this topic is easy. Correct, right? Tell me, gift of movable property. Is it required to be registered? Immovable property? First one. Instrument of gift of what property? Movable property. गलत किया है मैंने, चेंज कर लेना. It is what property? Movable property. What property? Movable property. Is it required to be registered? Not required to be registered. Not required to be registered. Next one, non-testamentary instrument. बोलो. Which CD illa RTI of how much? Value less than 100. Less than what? Any non-testamentary instrument that acknowledges the receipt or payment of any money on account of what? CD illa RTI of less than how much? 100. Is it required to be registered? Not required to be registered. Not required to be registered. And any lease not exceeding how many year? 1 year. Not exceeding how many year? Is it required to be registered? Not required to be registered. Not required to be registered. Next one, non-testamentary instrument transferring or assigning any decree of the court. What of the court? Which creates CD illa RTI to the value of less than how much? 100. In what property? Immovable property. Movable property, there is no requirement of registration. Yes or no? Next one. Next one is what? Will. Will is a testamentary instrument or non-testamentary instrument? Testamentary. Is registration of will mandatory or optional? You may register, may not register it. Other document not required by section number what? 17 to be registered. 7 to be what? Clear with this? Registration of document. Which document is mandatory? First one, gift of immovable property. Non-testamentary instrument, CD illa RTI, 100 and above. Non-testamentary instrument, acknowledging the receipt or payment, CD illa RTI, 100 and above. Next one, non-testamentary lease, exceeding 1 year, year-on-year basis, or reserving the yearly rent. Last one, transferring or assigning a decree or award of the arbitral tribunal which creates, declares, extinguishes, limits, assigns right, title or interest to the value of how much? 100 and above. Clear with this? Next one, time and place of registration. Where you are supposed to register your document. Every document executed in India should be registered within how many months of execution? 4 months of its execution. Bolo, how many months of execution? I repeat, documents executed in India should be what? Registered within how many months? Below how many months? In case of urgent necessary, the period is how many months? 8 months. Higher fees have to be what? Paid. For necessary reasons or emergency reasons, the registrar may extend up to how many months? 4 months. So totally 8 months. Next one, documents executed outside India within how many months of arrival in India? 4 months. But in case of stamp duty, within how many months? 3 months. How many months? 3 months. Yes or no? This is the time limit. Keep this in mind. Within how many months the documents are required to be registered? 4 months. How many months? Clear with this? Next one. Re-registration. Have you heard the concept of re-registration? What is re-registration? If an improper person make an application for registration and if it is already registered, on the discovery of the fact that it is already registered, the proper person may apply to whom? Registrar. Apply to whom? Registrar. Within how many months of knowledge? 4 months of knowledge. For registration, at that time, the registrar can do what? Re-registration. What registration? Because earlier it was applied for registration by an improper party. What party? Improper party. Clear with this? That is called as what registration? Re-registration. What registration? If a document is presented for registration by a person who is not duly authorized, not duly what? Authorized, bolo, not duly what? Not duly what? Authorized, present the what? Same, and it is what? Registered. That is what? Any person claiming under that document within how many months of becoming aware of the registration? 4 months of becoming aware of registration can present the document for what? Re-registration. What registration? How many months? Who can apply for re-registration? Proper person. What person? Proper person. Let us discuss who is that proper person who can apply for registration. The person who is the executant or is authorized agent, who is authorized by a special power of attorney. Bolo? Special power of attorney, not by general power of attorney. He should be specifically authorized for the purpose of registration of the document. Registration of what? Document. Or by the legal representative in case of his death. Correct, right? Registration of document. Registration of what? What is the place of registration? In which place or with which registrar you are supposed to register it? Within whose jurisdiction the property is situated? Bolo? Where the document is required to be registered, the document shall be registered at the sub-register office. What office? Within whose jurisdiction what is situated? Property is situated or any other registrar which is agreed by what party? Both the party. What party? Are you guys clear with this? Yes or no? Is a decree or order of a court required to be registered? No. Transfer is only if it is above how much? 100 and above. 100 and what? Above. Very good. Very good. Let's start. Place of registration. Place of what? The place of registration, the document shall be registered in the office of what registrar? Sub-registrar, within whose sub-district the whole or some portion of the relevant property is what? Situated in any office of the sub-registrar which is desirable by whom? All the executants. Copy or decree or order within whose sub-district it was made. Next one, presenting the document for what? Registration. Document for what? Who can present the document for registration? Some person executing or claiming under the what? Same. Or by whom? Representative or assignee of such person or the agent of such person or representative or assigned duly authorized by what? Power of attorney. By what? If other than this person, if anyone apply for registration and if it is registered, it is called, then you can apply for what registration? Re-registration. What registration? Compulsory affixing of what? Photograph. You need to attach the photograph. But nowadays, you take the photo in the office itself, the webcam. Okay. Next one, inquiry before what? Registration. Who can do the inquiry before registration? Registrar. Who can do the inquiry before registration? Registrar. Yes or no? Next one, date of operation of what document? Registered document. Important, important, important. And what date the document comes into effect? And the transaction take effect. Tell me, a document or a transaction take effect on the date of execution of contract or the date of registration? Date of execution. Registration is only a formality. Contract is made today, and I have how many months of time for registration? 4 months. I registered it after 3 months. So the contract take effect from the date of what? Contract itself. What itself? Contract itself. For example, contract is made on 1st of January 2023. Registration happens on 1st of March 2023. Tell me what is the date of registration? What is the date of on which the contract takes effect? January 1st, 2023. Are you guys clear with this? Are yes or no? Let's start. Registration, registered document shall operate from the date of the document, not from the date of what? Registration. Not from the date of what? Registration. Everybody, tell me on what date it comes into effect? Date of what? Date of what? Execution, not from the date of what? Registration. Priority among the two registered documents. If there are two documents, a single person has executed a two document for the same property and both are registered. Which one gets the priority? First one. Which one? First one. Clear with this? The one which is registered first and the one which is executed first. Clear with this? Now what if the one which is, like say, document contract 1, let's say X made a contract with Y, which is made on 1st January 2023. Second one with Z, 1st February 2023. This one is registered first. This one is registered later within the time limit. Which one gets the priority? X1 get the priority. First one gets the priority because it is always the date of what? Contract. Date of what? That is date of execution. Two registered document executed by the same person in respect of the same property Respect of what property? Same property to two different person at two different times. The one which is executed first gets the what? Priority over the which one? Other one. Although the former deed is registered subsequently to the which one? Later one. It is not the registration which gives the priority. It is the date of the contract that gives the priority at the date of execution. Date of what? Next one. Consequences of registration and non-registration. What happens if a document which is required to be registered compulsory but not registered? What are the consequences? Document which is required to be registered will not affect what property? Below what property? Immovable property. Unless it is what? Registered. It will not affect the contract. It is the transaction will not take effect unless the document is what? Registered. For example, if I have gifted an immovable property, what property? And if it is not registered, is that gift valid or not valid? Not valid. Next one, a document required to be registered confer the power to adopt will be invalid unless it is what? Properly registered. Adoption deed must be registered. Next one, document that requires registration cannot be received as what? Evidence. Affecting what property? Immovable property, unless it is what? Duly registered. Unless it is what? What are the three consequences of non-registration of document? What is the first one? No effect on what? Immovable property, unless it is what? Registered. A document required to be registered confers the power to what? Adopt. Will be invalid. Adoption deed must be what? Registered. And the third one, that the document which requires registration, if it is not registered, it is inadmissible as what? Evidence. Admissible as what? Inadmissible as an evidence. And there are three exceptions. Based on these three exceptions, there can be a practical question in the examination. So what are those exceptional cases where even though a document is not registered, still admissible as an evidence? What is the first one? Unregistered document. What document? Is related to the what performance? A contract. It may be received as a what? Evidence in a suit for what performance? Specific performance. What performance? What performance? One more time. If an unregistered document relates to the what? Contract, it may be received as a what? Evidence in a suit for what performance? See, for example, let's say you have entered into a contract with me. You have executed a sale deed also, but it is not registered. I am having possession of the property. Now I can file a case against you for what? Specific performance. What performance? Specific performance. So when I file a case against you for specific performance, I can produce this unregistered document as an evidence. As a what? To claim the what performance? Specific performance. What performance? Are you guys clear with this? Yes or no? Next one. Next one. Evidence of what performance? And below what performance? We have this concept of part performance under the Transfer of Property Act. Which are Transfer of what? Property Act. What is part performance act? See, where there is a contract for sale of immovable property, under the contract of sale of immovable property, if a person has taken the possession of the property, what of the property? And if he is ready and willing to perform his part of the contract, that is, the buyer is ready to pay the consideration, but the seller is not paying the what? Transferring the document or executing the sale deed. What did? And affecting the registration. So now the question is, can the person who is having the possession of the property be evicted from the property? No, because he has done his part of the contract or he is ready to perform what? His part of the contract is called as what? Part performance. What performance? I repeat, if a person has taken the possession of the property under a contract of sale, the person cannot be evicted on the ground that the registration is not affected, provided the buyer is ready and willing to perform what? Is part of the contract. What part of the contract? Is part of the contract. Buyer is ready and willing to pay the what? Consideration. Now, who should execute the sale deed? Seller. Correct. That is called as what? Part performance. What performance? So, in a suit for part performance, a unregistered document. What document? is admissible as what? Evidence. For example, Darshan has so entered into a contract with me to sell his property. I'm having the possession of the property. I am ready to pay the remaining amount. I'm ready and willing to perform my contract. But he is not doing the what? Registration, not doing the what? So without registration, sale is valid or not valid? Not valid. Yes or no? Now he filed a case against me. For what? Eviction. For what? Can I be evicted here? No. I can claim the part performance. What performance? Doctrine of part performance, which says that I cannot be evicted. Why? Because I'm ready and willing to perform what part of contract? My part of contract. And to prove this, I can give this unregistered document. What document? As a what? Evidence. As a what? Evidence. Clear with this? Last situation. Collateral transaction. What transaction? Not requiring what? Registration. Not requiring what? Registration can be admissible as what? Evidence. Admissible as what? So these are the exceptions where even though a document is not registered, but still admissible as what? Evidence. Everybody admissible as what? But in general, if a document is not registered, is it admissible? Not admissible? Not admissible. As a what? Evidence. As a what? As a what? Evidence. Are you guys clear about this? Yes or no? Next one. Next one. Tell me within how many months it's to be registered? How many months? Can there be extension? Up to how many months? 4 months. 4 plus 4. 4 plus what? 4. Next one. Precautions to be taken as a company secretary when you're working in a company. What are the precautions you should take during the registration of a document? Registration of what? Document. Let's start. What is the first one? Attest the what? Blanks. If there are any blanks on the document, it has to be attested, signed by the parties. Erasers as well as the alterations. Full and identifiable property descriptions. Check whether the property is assigned government or work or endowment lands, because dealing with this property is a punishable offense. What offense? What offense? If your company is entering into a contract to buy or sell these properties, you have to check whether it is a government property or a work property or endowment lands, that is charitable lands, because dealing with this kind of property is a punishable offense. What offense? Punishable offense. Next one. Document shall be presented within how many months of registration? How many months? How many months? 4 months. How many months? 4 months. Next one. Will deed can be presented. What can be presented? Will deed can be presented at what time? Anytime. Why? Why there is no time limit for will? Because registration is not mandatory for the will. Okay. Next one. Competent register and sub-registrar office. You need to present a document with whom? Competent officer. Next one. Should be presented by the person who is competent. Tell me who are the parties competent to present the document for registration? Executed, authorized agent, or any legal representatives, or the person claiming under him. Correct, right? Next one. Affix the what? Photograph as well as the fingerprints. Route map. What map? Address proof of the parties, witnesses, identifying witnesses, production of what? PPBs. What is PPBs? Pattadar passbook, and also TDs. What is TDs? Transferable development rights. What rights? No. TDs, title deeds. What deeds? Title deeds. And these transferable development rights are there. TDRs are there in where you are studying this? Tax. Okay, next one. Refusal by registrar to register the documents. Right? Now, if the registrar refuses to register the document, what are the remedies available to the applicant? Let's start. If the registrar, who registrar refuses to register a document, they must issue an order of refusal and record the reasons for the what? Refusal. Reasons for the what? A sub-registrar can refuse to register only on the ground that the property to which document relate is not situated within the what district? Sub-district. If an application is made to a registrar, he can refuse the registration only on what ground? The ground that the property is not situated within his jurisdiction. That is the only ground on which he can refuse the what? Registration. Undervaluation of stamp duty is not a valid ground for what? Refusing the registration. Appeal can be made to whom? Registrar. Against the order of the sub-registrar, you can go to where? Registrar. Go to home. Registrar. Appeal must be filed. What must be filed? Within how many days? Arey bolo, how many days? From the date of what? Order of refusal. Order of what? This appeal process is available for both compulsory as well as what? Optional registration. What registration? Within how many days? 30 days. How many days? If the registrar order for registration, the document shall be presented for registration within how many days of register orders? 30 days. How many days? Sub-registrar is then bound to register the document as directed by whom? Registrar. Directed by whom? Registrar. Are you guys clear with this? Against the sub-registrar, where you can go? Registrar. Within how many days? On what grounds the sub-registrar can refuse the registration of a document on the ground that the property is not situated within his jurisdiction. He can go for appeal to whom? Registrar. And if registrar order for registration, when the sub-registrar should do the registration within how many days of order? 30 days of order. Are you guys clear with this? Registration Act which year? 1908. 1908. Next one. Exemptions for document executed by or in favor of the government. So any document which are executed by or executed in favor of the government, are they required to be registered or not required to be registered? Not required to be registered. Not required to be. What are those documents? What are those documents whose registration is not required? What is the first one? Settlement deeds. Settlement documents. What documents? Arey bolo, what document? Document issued, received, attested during the land revenue settlement. What settlement? Land revenue settlement forming the part of what? Official record are exempt from what? Registration. There is a dispute between the landowners. The revenue officer will settle the dispute by what? Settlement. Is that document required to be registered? No. Next one, survey records. What record? That village accountant does a survey of the lands, who is cultivating the which property, and that survey is saying that, let's say the survey says Mr. X is cultivating the property. Is that required to be registered? No, it is not required to be registered. What is not required to be registered? Survey records. What records? Maps and documents prepared are authenticated during the government land surveys forming part of the what? Survey record do not require what? Registration. Next one, village records. What records? Array, what records? Village record. Periodic filings by the patwaris or revenue officers in the revenue office are exempt from what? Registration. Government grants. What grants? If a government give a grant of land to the public or to any specified person, is it required to be registered? No. Last one, Bombay Land Revenue Code notices. Any notices or notifications given under the Bombay Land Revenue Code is not required to be registered. Not required to be. And these are the provision with respect to what? Registration of document. Below what of document? Registration of document. Before I go to the next topic, let's revise and let's see how much we could retain, how much we retain in the discussions we had just. Okay? Tell me, registration of which document is mandatory? Gift of what property? Movable property? Tell me, shares or debentures? Transfer of shares or debentures. Is it required to be registered? Not required to be registered. Within how many months you're supposed to register? Where you will register? Which office? Within how many months? Who can apply for registration? Executant or legal representative or authorized person, or the agent of the executant or the agent of the representative duly authorized by what? Power of attorney. What of attorney? Power of attorney. Yes or no? Are you guys clear with this? 100%? Yes or no? Tell me, is will required to be registered? Will is a what? Testamentary. What is testamentary? That takes effect after what? Death of a person. Simple say, simple chapter. You read this much, solve the questions. You can answer any other question they ask you in examinations. Clear with this? Yes or no? Let's go to the what? Transfer of Property Act. Which act? Everybody, Transfer of which act? Property Act. Which year? 1882. Which year? Let us discuss some definition. What is the first one? Immovable property. What property? What is immovable property? It includes what? Land and benefit to arise out of what? Lands and things attached to the what? Earth. All these are called as what? What property? Immovable property. What are immovable property? Land, benefits to arise out of the land, and things attached to the earth. Any benefit arising out of the land. For example, collecting a fish out of the pond, it's called as what? Immovable property. What property? Mining is a what property? A right to do mining is a what property? Immovable property. Because the benefit is arising out of the land or anything attached to the earth. Now, when can we say something is attached to the earth? Is deemed to have been attached to the earth when it is embedded. When it is what? When it is what? Embedded in the earth, or if it is what? Rooted in the earth. What in the earth? Rooted in the earth. Something is attached to the earth if it is rooted in the earth in the case of trees and shrubs, embedded in the earth as in the case of what? Walls or buildings, attached to what is so embedded for the permanent beneficial employment. What employment? Permanent beneficial enjoyment. For example, windows, doors, all these are permanently attached to the enjoyment, right? They're called as what property? Immovable property. What property? What property? Next, we have absolute interest. What interest? What is absolute interest? When a person has all the bundle of rights, when he has every right of the property, it is called as what? Absolute interest. What interest? What is limited interest? You will be having a certain rights. For example, lease, rent. These are all what interest? Limited interest. What interest? What interest? Limited interest. Clear with this? Next one. Reversion and reminder. Important. Reversion and what? Reminder. See, the right which is left with the grantor or the seller, sorry, transferor, after he has given a limited interest. What interest? Limited interest. In favor of whom? Lessee or the grantee. It is called as what? Reversion interest. What interest? Means the property will revert back to me. If I give a lease of 3 years, how many years? I am giving a right to you, but I am keeping the ownership. It will come back to me after how many years? 3 years. इसको बोलते हैं reversionary interest. What interest? What interest? Reversionary interest. The residue of a original interest which is left after the grantor has granted the lessee what estate? Small estate. What estate? Reversion occurs when a property owner makes an effective transfer. What transfer? Effective transfer of property another but retains some future right to the property. What right to the property? Future right to the property. That is called as what? Reversion. Called as what? What is reversion? The residue of a original interest which is left after the grantor has granted the lessee a what estate? Small estate. Means a small right, a part of the ownership. Not part of the ownership, an interest in the property. What in the property? Interest in the property. Reversion occurs when the property owner makes an effective transfer of property to another but retains the what? Some future right to the property. What right to the property? Some future right to the property. Means property comes back to me. Then there is something called as reminder. Called as what? Where I give certain rights to one person. After the expiry of specific period, the remaining rights goes to whom? Or the residue goes to whom? To the some other person. Then he is called as what? Reminder. Called as what? He would be having a reminder interest. What interest? Reminder interest. A reminder is an interest in the property that is created when the owner of the property grants a limited interest. What interest? To whom? And upon the expiration of that limited interest, property passes to whom? Another person. See, in both the cases, a owner of a property gives a limited interest in the favor of another person. In the reversion, property comes back to the owner. Reminder, property goes to the other person. That is called as what? Reminder interest. What interest? Reminder interest. Clear with this? Owner grants a limited interest, and after the expiration of that interest, property reverts to the owner. It is called as what? Called as what? Reversion. If it goes to the other person, called as what? Reminder. Clear with reversion and reminder? Yes or no? Next, we have difference between reversion and reminder. Residue interest left with the grantor or original owner after granting a what interest? Limited interest. Future interest that passes to whom? What party? Third party. What party? Next one, who holds the interest? Reversion, owner. Remainder, third party. What party? Possession after expiry. Who gets the possession in case of reversion? Owner. Who gets the possession in case of remainder? Third party. What party? Next we have vested interest and what interest? Contingent interest. What interest? Interest here means right. If a right is already bestowed or already there with a person, it is called as what interest? Vested interest. What interest? If the right is already there with a person, it is already transferred to a person, it is called as what? Vested interest. For example, in case of ESOP, what's up? A person is supposed to work for minimum prescribed period of time. Right? That is called as vesting period. What period? Once that vesting period gets over, he gets the right. That is called as vested right. What right? Vested right. During that vesting period, it is called as what right? Contingent right. What right? You may get that right, may not get that right. If you work for 2 years, you get the right. So till the expiry of the 2 or 3 years, whatever it is agreed, it is called as what right? Contingent interest. What interest? After the expiry of that period, it becomes what interest? Vested interest. What interest? Are you guys clear with this? What interest? Vested interest or contingent interest. Clear? So vested interest means confer or bestow on someone. It can be of two types. Vested in possession, vested in interest. What is vested in possession? You have a right to ownership as well as the possession. It is a right where the person holding the interest or right is also entitled to the what? Immediate possession. What possession? What is vested in interest? It is a right where the person who has a right to future possession, but the right is already what? Certain and not dependent on any further condition. What condition? Further condition. That is called as what? Vested in interest. One case you have possession, other case there is no possession, but you get the possession on what date? Future date. What date? But right is already with you in both the cases. Vested means there is a right. Vested in possession means you have a right plus you have a possession immediately. Vested in interest means you have a right, but possession happens on a future date, but it is certain to happen. Clear with this? What is contingent interest? The right which is created and it will take effect on the happening or non happening of what? Specified uncertain event. What event? Specified what event? Uncertain event. If the event happens, it becomes valid. If it doesn't happen, it becomes what? Invalid. I am granting some shades to you, provided you work for how many years? 2 years. Is this a contingent interest or vested interest? You work for 2 years, it becomes what interest? Very good. Difference between vested interest and contingent interest. Which one is certain? Which one is uncertain? Where the person has right to possession? Vested interest. Correct, right? And where the possession depends upon the uncertain event? Contingent interest. Which one is transferable? Both are transferable, but one is heritable, other one is what? Not heritable. For example, in case of contingent interest, if the person dies before the event happens, legal heirs will not get that right. Except, but in case of ESOP, they get the right. But in case of transfer of property, which takes effect after fulfillment of a condition, the legal heirs will not get the what? That right. But in case of vested interest, what interest? Is it heritable? Is it heritable? Yes. Is it transferable? Yes. Yes. Next one. Effect of death. Effect of what? The interest passes to the legal heads or the transferees even if the whom possessor dies. Who dies? Possessor dies. But in case of contingent interest, it is not transferred. It is not what? Are you guys clear with the concept of difference between contingent interest and vested interest? Tell me what is vested in possession? Person having an interest has a right to immediate possession. What is vested in interest? Having an immediate right, but possession on what date? Future date. Correct, right? In case of reversional, what is reversionary interest? When an owner grants a limited interest after the expiration of which the property reverts to him, it is called as what? Reversionary interest. What is remainder interest? Grants a limited interest after the expiration of which the property transferred or interest transferred to whom? Other party. What party? And we're discussing which chapter? Transfer of property. Transfer of Very good. Awesome. Awesome. Let's start. Very, 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 very good. Let's start. Properties which cannot be transferred. Section number क्या है? 6. The properties which cannot be what? Transferred. Following properties. Can they be transferred? Cannot be transferred. Cannot be transferred. What properties cannot be transferred? A chance of an heir apparent succeeding to a what? Estate. I've given many examples for this. A son succeeding to the asset of the father after the death of the father. Can it be transferred before death of the father? No, he is not a son if it does that, because he is anticipating his father's death. Right, right. So he is not a son. Then he is what? Something. So the chance of an heir apparent. What apparent? Heir apparent succeeding to the what? Estate. Succeeding to the what? Estate. The chance of relation obtaining a what? Legacy of a death. Legacy of what? Death. See, if a person dies without having a kinsman, means what? Without having a blood relatives, the property goes to whom? His brother or the other family members. So is it a transferable right? No, unless until the death happens and you get the right, it is not transferable. Correct, right? So chance of an heir apparent, transferable, not transferable, not transferable. Chance of a relation obtaining a legacy of a death of kinsman, transferable, not transferable, not transferable. And mere possibility, mere what? Of like nature, transferable, not transferable, not transferable. Next one, mere right of re-entry. Right of what? I have given a lease. If the other person violates the lease, I can re-enter. Can I transfer the right to re-enter to someone else? No. But can I transfer ownership? Along with that, can I transfer right of re-entry? Yes. So mere right of re-entry. Transferable, not transferable, not transferable. Very good. Next one, easement. Next one is what? Array bolo, next one is what? Easement. Can easement be transferred? Cannot be transferred. Apart from the what? Dominant heritage. What heritage? I have a property next to your property. I have an access to my property over your property. Right to way. Right to what? Way. That is called as what? Easement right. What right? If I want to transfer this right to way, I must also sell my property to someone else. Can I just sell this right to way to someone else? No. You cannot transfer an easement right without the dominant heritage. Dominant what? Heritage. Clear with this? What is the first one? Chance of a heir apparent. Second one, mere right of re-entry. Third one, easement. Fourth one, interest in the property restricted in its what? Enjoyment cannot be transferred. For example, when a government grants the flat, or government gives the complex or the shops on a lease basis, only the person to whom it is granted should enjoy it. Can you sublease it? Can you transfer it? No. If you transfer it, is the transfer valid or not valid? Not valid. Why? Because the right is restricted in its enjoyment by the grantee. Only to particular person. Next one, right to future maintenance. Right to what? Arey bolo, right to what? Transferable, not transferable, not transferable. A right to future maintenance in whatsoever manner arising, secured, or determined cannot be what? Transferred. Cannot be what? A mere right to sue. A mere right to what? Can it be transferred? Cannot be transferred. Cannot be transferred. But along with the right to benefit, can it be transferred? Yes, it can be what? Transferred. It can be transferred. Next one, public office. What office? Can it be transferred? I'm a government officer. Can I transfer my work to someone else? No. Possible or not possible? Next one, stipends allowed to the military, navy, and air force, and civil prisoners. Sorry, civil prisoners, civil pensioners of the government, and the political pensions cannot be what? Transferred. Cannot be what? So these are the rights which cannot be transferred. They can ask question based on this in the examination. I will ask question. You guys should tell me whether it can be transferred or cannot be transferred. Tell me a mere right to sue cannot be transferred. Chance of an heir apparent. Public office. The interest which are restricted in its enjoyment to a particular person. Right of re-entry. Chance of a relative to the succeed to the property of the kinsman. Right to future maintenance. Can it be transferred? Cannot be transferred. Cannot be what? Transferred. Section number क्या है? 6. Clear with this? Yes or no? Restraint on the transfer or rule against what? Inalienability. Rule against what? Inalienability. Tell me, if a property is transferred with a condition that the buyer should not transfer the property, if there is an absolute restriction on the right to transfer the property, is that condition valid or not valid? Not valid. Yes or no? But partial restriction? Absolute restriction? But are there any exception? Yes, there are exceptions. We'll discuss that. Let's start. Property is transferred. What is transferred? Subject to a condition or a limitation restraining the transferee right of parting with or disposing his interest in the property absolutely. Then why are you purchasing it? You purchase it so that you can sell it to someone else, right? If I sell a property with a condition that you cannot sell it to anyone else, is that condition valid or not valid? Not valid. This condition of inalienability can be direct as well as indirect. Now, what if I say you should sell the property only at 1 rupee? Why will you sell at 1 rupee if the market value is 1 lakh rupees? It's an indirect restraint. What restraint? Valid or not valid? Not valid. But partial restriction, is it valid? Yes, valid. For example, we have a preemptive clause in case of company shares. What shares? Private company shares. In case of private company, the AOA may provide that the existing member should offer the shares to the existing members before you transfer them to whom? Outsiders. Is that restriction valid or not valid? Valid. It's a partial restriction. What restriction? I'm not saying you cannot sell. You can sell subject to this restriction. Are you guys clear with this? Yes or no? But what if I sell a property to you with a condition that I do not sell it to anyone else? Valid or invalid? Invalid. What if I say you should not sell below 1 lakh? Property is hardly worth of 10 rupees. But I'm saying you should sell only at what price? 1 lakh. Is that condition valid or not valid? Not valid. Clear with this? Next one. Exception. In the following cases, absolute restraint is valid. What is the first one? In case of lease. In case of what? In case of lease, the lessor can restrict the lessee from what? Subleasing it. What leasing it? Subleasing it. Next one, for non-Hindu, non-Buddhist, non-Muslim women, a condition that prevents them from transferring the what? Property during their what? Marriage. During their what? Is it valid? Yes, it is valid. Clear with this? What restriction is valid? Absolute restriction. Only in these two exceptions. Next, we have partial restriction. What restriction? A partial restraint is valid whenever there is conditions in the family for settlement and whereby members are not allowed to sell their shares to the stranger. Is that condition valid? Yes, family settlement. And in case of private company, what company? There can be a restriction that shares shall be offered to whom? Existing shareholders before they sold to whom? Public. Is that restriction valid? Valid or not valid? Because it is a what restriction? Partial restriction. What restriction? Then we have insolvency clause. Below what clause? अरे बोलो ना what clause? Insolvency clause. What clause? If a transfer includes a condition that transferee will lose the property if they become insolvent, is that condition valid or invalid? Invalid. Once you sell it, it is left to him. He can be solvent or insolvent. But however, if I give a property on lease basis, what basis? With the condition that if a lessee becomes insolvent, the lease is invalid. Is that condition valid or not valid? Valid. Clear with this? So any covenant or a condition in the transfer which restrains the buyer from transferring the property, is that condition valid or not valid? Not valid. Partial restriction? Valid. Are there any exceptions where even if there is an absolute restriction, that condition is valid? Yes. What are two restrictions? Lease. Next one. Non-Hindu, non-Muslim, non-Buddhist women, restricting them from transferring the property during their what? Marriage. Next one. Restraint on enjoyment. Restraint on what? Restraint on what? If you purchase this building, can you modify it? Can you sell it? Can you destroy it? That is your property. You can do whatever you want. Now, what if I sell a property to you with a condition that you should not do this, you should not do that, you should not cook non-veg in your house? Are those restrictions valid or not valid? Not valid. But are there any exception? Yes. There are two exception. How many exception? Two exception. There are not two exception, one exception. What is the provisions are? Any restraint below and the enjoyment of what? Property. Valid or invalid? Invalid. Where the land is transferred by one to the another, the transferor should not impose the condition as to how and in what manner the transferee should enjoy the property. Enjoy the what? If there are any such conditions, they are what? Void. Who the hell are you to put restrictions to how to use the property? I am buying it. I'm paying you the money. I will do whatever I want. I will buy the house. I'll dump garbage in the house. Just because you have an emotional connection with the house doesn't mean I'll do whatever you say. And you don't have a right to put any restriction. Correct, right? But what if there are two houses? You are selling one of the houses to me, and for the better enjoyment of both the property, you put a condition saying that you're not supposed to use it for collection of garbage, or you're not supposed to construct more than one floor, so that both of us will get a natural air, natural light, and other benefits. Is that condition valid? Yes, that is the exception. Clear with this? Let's read. If a person transfer a plot of land, keeping another plot for himself, he can impose certain conditions which may interfere with the what? Right of enjoyment of the transferee. Enjoyment of what? Yes or no? Are you guys clear with this, everybody? Next one, next one, next one, next one. Now tell me, Darshan, tell me, if there is an absolute restriction, what restriction? On the right to transfer the property, is it valid or not valid? Condition valid or not valid? Transfer is valid. Only the condition is invalid. What is invalid? Condition is invalid. Buyer is not bound by it. Can there be a partial restriction? Yes or no? Are there any cases where even though there is an absolute restriction, is the condition is valid? Yes. Lease. Non-Buddhist, non-Hindu, non-Muslim woman during the war. Marriage. During the war. Tell me, can there be a transfer of property to the benefit of an unborn person? Yes or no? Can we transfer a property to an unborn person? Yes, provided it satisfies three conditions. What are the three conditions? It should be preceded by what interest? Life interest. What interest? Means you have to transfer it to a person who's already there. And you need to transfer everything. You need to transfer what? Everything. Absolute interest must be transferred to the unborn person. What person? Unborn person. Yes or no? Yes or no? Then what is valid? Transfer for the benefit of unborn person is valid. Unborn person means who is unborn person? He is not in the existence, even in the what? Mother's womb. Property can be transferred to a person who is in the mother's womb, but property cannot be transferred directly to a person who is not even in the what? Mother's womb. Because such person is called as what person? Unborn person. What person? Then how to transfer it to him? The transfer must be preceded by what estate? Life estate of a person who is living. The interest created for the unborn person must comprise the what? Whole of the remaining interest of the transferor in the property. Now I transfer property to the X for the lifetime, and after death of her, the property should go to the unborn child. What child? Is this transfer valid or not valid? Valid or not valid? Valid. Preceded by a life interest, absolute interest is transferred. Now, what if I say I transfer the property to X for the lifetime? After her, the first son for 10 years. After that, to the second son for lifetime. Is it valid or not valid? Not valid. Because what should be transferred? Absolute interest. What interest? What interest? In favor of whom? What child? Unborn child, not unborn baby. Unborn child. What child? Unborn child. Next one, rule against perpetuity. Rule against what? Arey bolo, rule against what? Perpetuity. If states that transfer of property that takes effect after what? Perpetuity is void. If I say, for example, I'll make a transfer saying that property goes to Darshan for 10 years. After the 10 years, it goes to Surya for 20 years. After that, it goes to Chiran for 10 years. But after that, it goes to Adi for 10 years. then Vinay for 10 years, then Hemant for 10 years, Danush for 10 years, Girish for 10 years. After that, it goes to Mahesh for 20 years, then to Prashanta, Jeevan, and to Manoj. Is this transfer valid or not valid? I am controlling how the property should be transferred in perpetuity, right? Is it valid or not valid? Not valid. Yes or no? The maximum period for which the transferability of the property can be suspended is the life of a living person and minority of a unborn child. What child? Now I can say I am transferring the property to the life of a living person and to the minor child. What child? An unborn child up to 18 years. How many years? Is it valid? Yes. Such types of transfers are what? Valid. Transfers are what? The right of an owner to transfer or alienate his property should not be exercised in a way that restricts the what? Transfer of property. The maximum period of inalienability allowed by the law is the lifetime of the what person? Living person, and the minority of what person? Ultimate beneficiary. Are what beneficiary? Ultimate beneficiary. If the transferor imposes a restriction that lasts beyond the lifetime of a living person, lifetime of a what person? And the minority of what? Beneficiary. Transfer is valid or void? Void. Void. Exception where the transfer of property is for the benefit of the public in advancement of religion, knowledge, commerce, health, safety, or any other object beneficial to what kind? Mankind. What kind? What kind? Then is it valid? Yes. If I transfer the property to a trust saying that it is not transferable at all, is it valid? Yes, it's for whose benefit? Public benefit, right? Whose benefit? Public benefit. Valid or not valid? Valid. Clear with this? This is called as rule against perpetuity. Rule against what? Next one, effect of transfer on a failure of prior interest. What interest? Prior interest. See, listen, if a prior interest fails, what also fails? Subsequent interest also fails. You get a ownership, she gets a ownership. When you don't get a ownership, how she will get a ownership? I made a transfer to Manoj, and Manoj made a contract with whom? Jeevan. If the transfer to Manoj itself is invalid, then transfer to whom is also invalid? Jeevan is also invalid. If the prior interest fails, what fails? What also fails? Subsequent interest also fails. That is called as what? Effect on transfer on failure of what interest? Prior interest. What interest? Prior interest. Clear with this? What is the first condition? If a transfer creates, what creates? If a transfer creates an interest for a person or a group of people and the interest fail for any reason, any subsequent interest created in the same transaction that depends on the prior interest will also what? Fails. Prior interest also fails. If the transfer to you depends upon a prior interest, if that fails, your interest also fails. Clear with this? Next one, accumulation of income. Accumulation of what? I transfer a property to you with a condition that whatever the income comes out of this property should be accumulated to be paid to me. Is it valid or not valid? Not valid. For a particular period of time, it is valid. For a lifetime, not valid. Lifetime, not valid. Accumulation of income. Bolo? From the what? Land of an unlimited period. What period? Without the what? Income being enjoyed by the owner of the property is not allowed. Is not what? Allowed. Correct, right. You are holding the property. I take all the benefit. Then why the hell did you purchase the property? Correct, right? It's accumulation of income. Accumulation of income from the land for an unlimited period. What period? Without the income being enjoyed by the owner of the property is not, because the reason you buy the property is to enjoy the benefit of the property. Right, right? So such conditions are not valid. The law allows the accumulation of income for a certain period only, but not only certain period only. The period for which such accumulation is valid is what? Life of the transferor. Life of the what? Transferor. If I transfer property to you with a condition that whatever the rent comes out of the property should be paid to me till my death. Is that condition valid? Yes. But what if I say till my death, till my wife death, till my son death? Is it valid or not valid? Not valid. Only the life of the womb transferor. Life of whom? Transferor. Next one, 18 years from the date of what? Transfer. Either life of the transferor or 18 years from the date of transfer, whichever is higher. Any direction to accumulate the income beyond the period mentioned above is valid or what? Void. Condition is void. इसको बोलते हैं accumulation of income. Accumulation of what? Income. You guys tell me any condition for accumulation of income uncertainly without specific period. Is it valid or not valid? Not valid. Valid or not valid? Are there any to what extent it is valid then? Life of the transferor or how many years of time? 18 years from the date of transfer. Clear with this exception? In the following cases, a direction for accumulation of income beyond the period prescribed above is what? Allowed. When? For the payment of what? Debts of the transferor. It can go beyond how many years? 18 years. How many years, sir? Our income can be accumulated for the maintenance, education, support of whom? Children or any other person who is to take the interest in the property under the what? Transfer for the benefit of the children or the family members. Next one for the preservation and maintenance of what? Property transfer. See, when you take a buy a flat, they put a condition that you're supposed to pay maintenance expenses, right? Supposed to pay, and when it will be for what? Perpetuity for the maintenance of the property. Is it valid or not valid? Valid. Next one, doctrine of lease pendens. What pendens? There are three doctrines, important doctrines, not three doctrines, two doctrines, important doctrines, based on which they generally ask questions in the examination. What is the first one? Lis pendens. What is lis pendens? Lis means litigation. Pendens means what? Pending. What is lis pendens? Simple says simple. During the pending litigation, nothing new should be introduced. Hello? During the pending investigation, what should not be introduced? Nothing new should be introduced. Means you should not transfer it. You should not create any right over the property. Correct, right? Because what is pending? Litigation is pending. What if you do? If you transfer it, what will happen in that situation? Is the transfer valid or not valid? Not valid. It is called as doctrine of what pendants? List pendants. What pendants? Let's start. List means what, bacho? Litigation. Pendants means what? Pending. What is list pendants? Pending litigation. Pending what? Litigation. During the pendency of a suit, the property in dispute cannot be transferred. Cannot be. The doctrine of list pendants is based on the principle that like pendant nihil invention. During the pendency of litigation, nothing new should be introduced. That is what I am saying. Yes or no? Essentials conditions for the applicability of this doctrine. A suit or a proceeding is pending before the court having jurisdiction. The pending suit is for what? Right to immovable property. The suit or the proceeding must not be collusive. Should not be what? Collusive, not be based on what's a bad faith or malified intention. Property in dispute must be transferred, otherwise dealt with by whom? Any party to the suit. The transfer must affect the rights of which party? Other party to the litigation. Only what is applicable? List pendency is applicable. A suit in a foreign court cannot operate as what? List pendants. Doctrine of list pendants does not apply to what properties? Movable property. What property? It's only applicable for which property? Immovable property. 53A. I will discuss section number 53A. Doctrine about performance. Part performance. Tell me for the part doctrine of part performance. An unregistered document be admissible as an evidence. अरे ऐसा नो registration act अभी तो discuss किया हम लोग. We just discussed about the doctrine of what performance are. Part performance. Let's read what is doctrine of part performance. It's a equitable doctrine. What doctrine? I've already explained it. Just read the points, so you'll understand the concept. If not, I will explain it. CSR, hey now. Read. And CSR is here. Why do you fear? You're only the fears. If a person has taken the possession of immovable property on the basis of contract of sale and has either performed or is willing to perform his part of the contract, then he would not be ejected from the property on the ground that the sale was unregistered and the legal title had not been what transferred to him. Because this document is compulsory registerable, not registered, ownership will not be transferred. Just because ownership is not transferred, can that person be evicted from the house? Can be done or cannot be done? Why cannot be done? Because of doctrine of part performance. What performance? In this situation, can the person who is having the possession of the property produce the unregistered document as an evidence? Yes or no? Simple. Otherwise, clear with the concept. See, I have made a contract with you to sell this building. Agreement is done. And you have taken the possession of the property. But registration is not done. What is not done? Agreement is made, registration is not done. You're already having a possession of a property. Now I filed a case against you for eviction. What is eviction? To evict you from the property on the ground that you're not having the ownership. At that time, what court can apply? Doctrine of part performance. You cannot be evicted from the house just because registration is not done. If you are ready and willing to perform, you are part of the contract. What of the contract? Part of the contract. And for this purpose, you can produce the document which we have executed, even though it is not registered as a what? Evidence. As a what? Clear with this? Next one. Essentials for applicability of doctrine. What is the first one? There must be a contract to transfer what property? Immovable property. It must be for what? Consideration. Contract should be in what? Writing and signed by whom? Transferor. Terms must be what? Ascertainable with reasonable certainty. The transferee should have what? Taken the possession of property. What of the property? The transferee must have fulfilled or ready to fulfill is what? Part of the obligation. What of obligation? He already fulfilled his obligation or ready to fulfill his. That's what I was saying, right? Either he has done the payment or ready to make the payment. In this situation, what is applicable? Doctrine of part performance. What performance? And these are the provisions with respect to transfer of property. I will ask you questions before I go to the next topics. I'll ask you questions to you guys, which should answer. Okay, listen. I'll ask practical question. I'll give some situation. Tell me what will happen in the case. Yeah, listen. So provision relating to the specific transfer of property. What is the first one? Sale. What is sale? Transfer of ownership in the property for consideration. This is called as what? Sale. Transfer property for consideration. It is called as what? Sale. Formalities of sale. There must be execution of what contract? Return contract. Should be attested by how many witnesses? Two or more witnesses. Registration is mandatory. What is mandatory? Registration if the value of the property is how much? 100 and above. And once a document is registered, it acts as a what notice? Constructive notice. What notice? What is constructive notice? Anyone who deals with a property is deemed to be aware about it. It is called as what? Constructive notice. What notice? Constructive notice. Clear with this? Formalities of what? Next one, exchange of property. What are property? Exchange of property. What is exchange of property? Transfer of ownership of property for a consideration of what? Ownership of another property. Next one, mortgage. What is mortgage? Transfer of what? Interest in the property. What in the property? So transfer of interest in a specific immovable property for securing the payment of money or the performance of a promise. It is called as what? Mortgage. Called as what? I give an immovable property as a security, either for the repayment of debt borrowed or the performance of a promise. I say, like, if I don't perform the promise, you can recover the property or you can recover the money by selling the property. That is called as what? Mortgage. Mortgage is done for what property? Immovable property. What property? There is a transfer of what? Interest. Transfer of what? Interest. Types of mortgage. What is the first one? Simple mortgage. What mortgage? Mortgager binds himself personally to pay the what? Debt. To pay the what? Debt. Mortgage have a right to get the decree of the court for the application of what? Property in the payment of debt. Payment of what? Debt. No right of possession or foreclosure is available. You just have a right to keep the property as a security, and on default, we can file a suit for the what? Order of the court to sell the property and to recover the money. You cannot take the property as your own. In case of what mortgage? Simple mortgage. What mortgage? Next one is what mortgage? Mortgage by what? Conditional sale. What sale? It is mortgage by conditional sale. In the event of failure by the debtor, transactions will be considered as what? Sale. I transfer the property to you with a condition that if I default, you become the owner. That is called as what? Mortgage by conditional sale. Next one is what? Usufructuary mortgage. What is usufructuary mortgage? The mortgager transfers the property to whom? Mortgagee, and mortgagee has to recover the interest. Recover the what? The interest payable and also the principal repayable based on the benefit arising out of the property. For example, I take a loan from the bank to buy a property and I give the possession of the building to whom? Bank. And I say you recover the interest and the principal amount out of the benefit arising out of the what? Building. That is called as what? Usufructuary mortgage. What mortgage? Usufructuary mortgage. Next one. What mortgage? What is English mortgage? The mortgager transfer the property absolutely. This is opposite to which mortgage? Mortgage by conditional sale. What sale? Conditional sale. Where in case of English mortgage, the mortgager transfers. Who transfers? Mortgagers transfer the property to whom? To the mortgagee. With the condition that if you make the payment, the mortgagee should retransfer the property back to whom? Mortgager. I have already transferred the property to you with the condition that you should transfer it back to me if I make the payment on time. That is called as what? English mortgage. What mortgage? See, in case of conditional sale, I am transferring the property with the condition that the transfer will take effect only when I default. But in English mortgage, property is already transferred. You are the owner with the condition that if I make a payment, you should retransfer it or transfer it back to me. That is called as what mortgage? English mortgage. What mortgage? In the conditional sale, ownership is not transferred. It is transferred only when I default. In English mortgage, ownership already transferred with a condition that it shall be transferred back if payment is made. Payment is what? Made. Next one, mortgage by deposit of title deeds. It is also called as English mortgage. On default, creditor can file a suit for the what? Not English mortgage, equitable mortgage. What mortgage? Equitable mortgage. Change it. It is also called as equitable mortgage. On default, creditor can file a suit for recovery or on the basis of having the title deeds in his possession. You just give a title deeds. What deeds? Title deeds. Next, we have anomalous mortgage. What is anomalous mortgage? Combination of two or more forms of mortgages. Above it is called as anomalous mortgage. Next one, sub-mortgage. What is sub-mortgage? When the mortgagee further mortgage the property, it is called as what? Sub-mortgage. What mortgage? Design mortgage means what? When the mortgager mortgages the same property to second person. What person? To secure the repayment of a debt. The second mortgage is called as what? Design mortgage. Second one, I am giving the same property as a security for more than one debt. The second one is called as what? Design mortgage. Next one, rights of the mortgager. What are the rights of mortgager? He can redeem it after making the what? Payment of debt. Payment of what? Debt. Second one, right against clog on equity. What is clog on equity? If there is any condition on the mortgage deed which provides that mortgager cannot redeem the property back even on payment of debt. Is it valid or not valid? Not valid. It is called as clog, void in the mortgage deed. that condition is not valid. If there is a condition in the mortgage deed which provides that the mortgager cannot redeem the property back, cannot redeem the what? Property back on the default by whom? On the default by whom? On the repayment of debt. Is that condition valid or not valid? Not valid. इसको बोलते हैं clog on what? Equity of redemption. Next one, right of what redemption? Partial redemption. Two different contracts are made, two different properties, and if I make a part payment, what payment? I can redeem the part of the property. What of the property? These are the rights of whom? Mortgager. Next one is what? Charge. What's the next one? So when an immovable property is given, what is given? Immovable property is given as a security for the what? Payment of money, either by the act of the parties or by what? Operation of law. What of law? That is called as what? Charge. See, mortgage is only by act of the parties, but charge can happen based on what? Act of the parties or by operation of law. Types of charge: by the act of the parties or by operation of law. It can be floating charge as well as what charge? Movable properties are where the charge creator can deal with the property even after charge is created. It is called as what? Floating charge. What charge? If the charge holder cannot deal with the property after the charge is created, it is called as what? Fixed charge. What charge? Difference between charge, mortgage and charge. Mortgage, there is a transfer of interest. Charge, there is no transfer of any interest. Next one, only by the act of parties, but charge by the act of the parties or by what? Operation of law. Mortgage need to be in what? Writing. Charge can be in writing and also what? Need not be in writing and what? Registered. Mortgage can foreclose the property. What is foreclose the property? You can take the ownership of the property. But charge cannot foreclose the property. Mortgage, there can be no personal liability, but charge, there can be what? Sorry, mortgage, there can be personal liability. Charge, there can be no personal liability. Then we have lease. What do we have? What is lease? Transfer of right to enjoy the property. Enjoy the what? It is called as what? Lease. Called as what? What is lease? Transferring right to enjoy the property. It is called as what? Lease. Called as what? Termination of lease. The lease gets terminated in the following cases or comes to an end in the following cases. What is the first one? Influx of time means expiry of time. Given for 3 years, expires, comes to an end. Next one, happening of what event? Special event. What event? We have agreed that on the happening of this event, lease comes to an end, and the event once the event happens, lease comes to an end. Next one, merger of rights. What rights? When I call, for example, let's say I have given a lease of this building for 10 years. After within 10 years, you have purchased this property. Once you purchase this property, what comes to an end? Lease comes to an end. Next one, surrender of lease. Who can surrender the lease? Lessee. To whom? Lessor. Correct, right? Then what comes to an end? Lease comes to an end. Next one, forfeiture. Who can forfeit the lease? Lessor for violation of any of the terms of the lease. In all these cases, what comes to an end? Lease comes to an end. Next one, duties of whom? Lessor. Duties of whom? Disclose the word material defects. What defects? Possession of the what? Property. What of the property? Possession of the property. Who can disclose the material defects? Lessor. And he also has the right to claim the what? Possession of the property. Possession of the what? Property. Once he's supposed to give a possession to whom? Lessee. Right, right. If there is any defect in the property, is it required to disclose it to the lessee? Yes. And quite enjoyment. You should not disturb the possession of the property of the lessee. Next one, rights of the lessee. Can he enjoy the accretion to the property? What is accretion? Increase. If I have given a land on a lease basis, on that in that land there are mango trees, and if there are mangoes in the trees, that mangoes belongs to whom? Lessee or lessor? Lessee, because you are the one who is having the lease over the property, right? I know. So any accretion, who can enjoy it? Lessee can enjoy it. Next one, carry out what? repairs and deduct the expenses from the rent. Deduct the what paid? Taxes paid. What paid? Taxes paid. Who can deduct the taxes paid? Lesser or lessee? Lessee. If who is supposed to pay taxes? Lesser. But who paid it? Lessee. Can deduct it from the what? Lease amount. Next one, remove the fixtures. If he has affixed any fixtures, if he is vacating, he can remove those fixtures. Next one, entitled to all the crops planted are grown by whom? Lessee. Grown by whom? Lessee. Right, right. Next one, can avoid the lease if the property is wholly or partially destroyed. Well, if you have taken a house on lease basis, house is destroyed, avoid the lease. Last one, lessee can sublease the what? Property unless there is a express prohibition. What prohibition? Express prohibition. Next one, gift. What is gift? Transfer of property without consideration. Tell me, gift of immovable property requires registration, not required to be registered. Required to be registered. Required to be revocation of gift. Is it possible or not possible? Gift cannot be revoked unless it is a what? Revocable gift. What gift? Property transferred with or without consideration, it is called as what? Gift. A gift cannot be revoked. However, revocable gift can be revoked. What can be revoked? Revocable gift can be revoked. Condition to be satisfied. Donor and donee must have agreed for the what? Revocation of gift on the happening of what event? Specified event. Is it revocable? Yes. On the happening of what? Event. Event should not depend upon whose will? Donor will. Whose will? Donor and donee must have agreed to the condition at the time of what? Contract, and the condition should be what? Should not be illegal. What is honorous gift? Honorous gift means a gift comes with liability is called as what? Honorous gift. If I give a property as a gift, property as a what? Gift. Property as a what? And along with that, there are some liabilities. For example, I am giving you property worth of 1 lakh with the condition that you are supposed to pay remaining 2 EMIs on the property. It is called as what? Honorous gift. Is it valid or not valid? Valid, but you have to accept the liability as well as the right. What if you say, no, no, I'll only take the property, I'll not pay remaining EMIs? Is it valid or not valid? Not valid. Clear with this? So any gift which comes with liabilities, it is called as what? Onerous gift. A gift which is made along with the obligation, it is called as what? Onerous gift. Where several things are transferred by a single transaction, the donee has to accept the what? Entire transaction. What transaction? In case of two or more separate and independent transfer, the donee can accept the what? One and refuse the which one? Other one. Separate and independent, you can reject one and you can accept the other one. But in case of onerous gift, you have to accept the what? Both. Clear with this? Next one, actionable claim. What claim? What is actionable claim? A right to claim a what debt? Unsecured debt. Well, what debt? A right to recover the unsecured debt. It is called as what? Actionable claim. What claim? Which the civil court recognizes as a offered in the grounds for relief of the person claims it. It is called as what? Actionable claims. Examples for actionable claim: arrears of rent accrual constitutes a what? Debt. It is an actionable claim. What claim? Arrears of rent. Or if I sell the goods on credit basis, if I have a right to recover the debt back, it is called as what claim? Actionable claim. What claim? Provident fund that standing to the credit of the member is also called as what claim? Actionable claim. Is it transferable or transferable? Transferable by a registered document. What document? Because an actionable claim is considered as immovable property. What property? Come under the Transfer of Property Act, not the Sale of Goods Act. Clear? Next one, money due under the what? Insurance policy. What policy? What policy? It is also called as what? Actionable claim. Next one, easement right. What right? You know what is easement right? The right to way, right to light, right to enjoy, not enjoy. Where you have a right over someone else's property to enjoy your own property, it is called as what? Easement rights. What right? A right to enjoy a property out of the land of whom? Another is called as what right? Easement right. What right? It exists for the accommodation and better enjoyment of whom? Land to which it is annexed. The land owned by the possessor of the land is known as the what? Dominant tenement. What tenement? And the land over which the right is enjoyed is known as what? Servient tenement. Servient what? Tenement. They can use these words to ask questions in the examination. Dominant tenement means the property which belongs to you. Servient tenement means what? A property on which you have a easement rights. What right? Tell me, are easement rights transferable or transferable? Along with dominant heritage, trans- clear with this? Yes or no? And with these, we are done with what? Law with respect to registration. With respect to, are you guys able to recall all the concepts of Registration Act as well as the Transfer of Property Act? What act? Transfer of Property Act. Transfer of. Clear with this? Yes or no? So let's solve the questions asked in the previous exams. What is the first one? Question number one. Mark it important. Based on this, there can be a question in the examination. What is the object of the law of registration? Object of what? Law of registration. Preservation and record of such document. Uh, it's particularly important in the case of immovable properties because the history of the rights need to be established. Documents which are required to be registered act as a what? Act valid evidence in the court of law. Document which are need to be compulsory registered, not admissible as evidence in the court of law if it is not registered. You write the object of Registration Act. Documents which are compulsory registrable, section number 70, CD law, RTI. Amrit, question number two, practical question. Let's read the practical question. Amrit executed a gift deed in his lifetime in favor of Hanu. The gift deed was not registered during the lifetime of Amrit. Hanu, after death of Amrit, presented the gift deed before the before the registrar for registration. Rakshit, brother of Amrit, raised an objection to the registration of the gift deed on the ground that can the registration be done even after death of the executor? Yes. Within how many months? 4 months. How many months? Registration is mandate. If it is a gift of what property? Immovable property. A death of a person before registration will not affect the what? Will not affect the what? Or the affect the validity of the document. Clear with this? So like this. Okay, let's start. Lesson 14. Right to information law. See, as per Article 19(1)(a) of the Constitution of India, every citizen of India has a right to express one's opinion and convictions freely, either by words or by signs or any visible representations freely. Correct, right? That is what Article 19(1)(a) provides. And Article 19(1)(a) also includes right to obtain the information. Why? Because a person can express an opinion. Express what? Opinion. Only when he has what? Information. So information is essential for exercising the fundamental right to speech. So based on that, there is a law called as Right to Information Act, which provides the right to the citizen seek information from the public authority. What authority? Public authority. This act gives the right to the citizen of India and duty on the public authority. So citizens have a right to seek information and the government public authorities have an obligation to provide the information. Obligation to provide the what? Information. Clear? So let's discuss the provisions of what? Right to Information Act. Right to know. This is important. Based on this the case they asked question in the previous examination. Right to know in the Reliance Petrochemicals Limited versus Indian Express newspaper, the Supreme Court of India identified are recognized. The right to know. What to know? Right to know is the intrinsic to the right to participate in what? Democracy. The court has held that right to know is intrinsic, means it's essential to what? Participate in what? Democracy. Participate in the what? Democracy. In a participatory democracy, informed citizens, what citizens? Informed citizens are right for making the what? Decision, voting, and contributing to the what? Societal progress. Who is important? Informed citizens. Bolo, informed citizens are important for making decisions and voting and also contributing to the what? Societal progress. So that is why a right to know, a right to information is an essential right. What right? Essential right. This was held in which case law? Reliance Petrochemicals Limited case law. To participate in a what? Democracy, in a participatory democracy. With the globalization and the increasing interconnectedness of nation, the meaning of liberty extend includes what? Right to information. Right to what? Information. So the liberty also includes what? Right to information. Right to what? Supreme Court extended the scope of Article 21. What is Article 21? Article 21 deals with right to life and personal liberty. So, Supreme Court has held that right to life also includes even right to know, a right to have the information. Individuals have a right to seek, receive, and impart information as a part of what right? Fundamental rights. What rights? So Supreme Court has extended the application of Article 21 to include the right to know. What to know? Right to know, which includes a right to seek, receive, and impart the information as a part of what right? Fundamental human rights. Fundamental what right? Human rights. Right freedom of speech and expression includes right to information has what? Knowledge and informations are prerequisites for forming and expressing the what? Informed opinions. What opinions? Informed opinions. Clear with this? Yes or no? This is what held in which case law? Reliance Petrochemicals Limited case law. Clear? So right to know is essential in what democracy? Participatory democracy. For what purposes? To exercise the voting rights and to make decisions and to contribute to what progress? Societal progress. Correct, right? And with the interconnectedness of the nation, the meaning of liberty extended even to what? Right to information. Right to what? Not only for the physical liberty, even to have the informations, correct, right? And the right to know is held to be part of right to life. Right to what? Life. So every person has a right to seek and receive and impart, that is, teach what? Information. Teach what? Information. Clear with this? This is what happened in which case now? Reliance Petrochemicals Limited versus what? Indian Express. What Express? Indian Express. Next one, objectives of RTA Act. Which Act? What is RTA Act? Right to information. What is the first one? It brings the greater transparency in the administrative departments. Correct, right? Because public authorities feels accountable the citizens, because citizens can seek what? Informations. So greater transparency in functioning of authorities, public authorities. Next one, informed citizenry. Correct, right? Citizens will have an informations. They will be having more information to form the opinions. Next one, improvement in the what? Accountability. Who feels accountable? Public authority, because they're supposed to provide the informations. Last one, reduction in corruption. Indirectly it helps to what? Reduce the corruption. Reduce the what? Corruption. These are the objectives of what? RTA Act. Which Act? RTA Act. Which Act? RTA Act. What is the first one? Greater transparency. What transparency? Greater transparency. Second one, informed citizenry. Third one, improvement in accountability. And the fourth one is what? Reduction in corruption. Reduction in what? These are the objectives of which Act? RTI Act. This important. See, who has a right? Citizens have a right. And who has the obligation? Public authority. So we must know who is public authority, right? Because citizens have a right to seek information from the public authority. Now, who is a public authority? Public authority means, listen everybody, public authority means authority, body, institution. Bolo? Authority or a body or institution established or constituted. An authority or a body or institution established or constituted by or under the Constitution of India. For example, we have UPSC Commission is established as per the what? Constitution of India. Correct, right? So authority includes any, sorry, public authority includes authority, body, institution established by the Constitution of India or by any other law. What law? Made by whom? Parliament. Made by whom? Parliament. Or by and other law made by what legislature? State legislature. What legislature? State legislature. Or by notification issued or order made by what government? Appropriate government. What government? Are you guys clear with this? Tell me what is public authority? Authority, body, institution established or constituted under the constitution or by the law made by parliament or by a law made by state legislature by notification issued or order made by appropriate government. Clear? It includes what? Body owned or controlled, substantially financed. हम लोग डिस्कस किया था ना instrumentality of a state. Other authority, what authorities? Other authorities. Correct, right? Next one, non-governmental organizations, NGOs, which are substantially financed directly or indirectly by the funds of appropriate government, are also called as what? Public authority. Authority. So who has the obligation as per the RTA Act? Provide the information to whom? Citizens. Citizens can seek the information from the public authority. Authority, public authority. Seek the information, sir. What is the procedure to be followed? Listen, everybody. Request for information. What for information? Only who can seek information? Citizen. Any person desires to obtain the information shall make a request. Shall make a what? In what? Writing or electronically, accompanying such fees as may be prescribed. As may be what? Right. To whom is supposed to make an application? To the Central Public Information Officer. Bolo? Central. If it is a central government office, there will be a central public information officer. If it is a state government public authority, state public information officer. For example, under MC, we have ROC. In ROC, we will have what? In the ROC, we will have what? SPIO or CPIO? CPIO, Central Public Information Officer. Bolo? Central Public Information. Because it's a central government department, right? Yes or no? So you need to make an application to the either CPIO or the SCPIO. Next one, application is made to whom? Public authority, and the information is held by whom? Another public authority. In that situation, the public authority to whom the application is made, it will forward the application within how many days? 5 days. To which authority? Other public authority. Time limit for supply of information. Within what time the information must be supplied? By whom? Public authority. Information to be supplied as expeditiously as what? Possible. As soon as possible. And in any case, within how many days? 30 days of the receipt of the request. How many days? 30 days. Within 30 days, you should try to provide the information sought by the citizens. Who should provide the information? CPIO or SPIO. If the application is made to the assistant public officer, then the information should be submitted within how many days? 35 days. There will be a CPIO or assistant CPIO. SPIO or assistant SPIO. If it is made to CPIO, 30 days. Or assistant CPIO, 35 days. Clear with this? Next one. If the interest of third party involved, what is involved? If you are seeking a information which is with respect to third party, in that situation, how many days? 40 days. Why? Because the public authority must give a notification or must give a notice to whom? Third party before disclosing the information to the citizens. इसीलिए there is how much time? 40 days time. Clear? So within how many days the public authority should supply the information? 30 days. How many days? 30. CPIO? 30 days. 30 days. Assistant CPIO? If the interest of third party is involved, 40 days. Clear with this? Life or liberty of a person is involved, 48 hours. If it is a question of life or liberty of a person, then the information should be submitted within how many hours? 40 hours. For example, my pension is not paid. Let's say I'm 90 years old now. How many years old? 90 years old. I'm getting some pension. My pension is not paid since 1 month. Without pension, how will I survive? I have to buy food articles, correct, right? Now I sought information from the public information officer why my pension is not paid. This information should be given within how many hours? 48 hours. It's about life and liberty of a person. Somebody has been arrested. My friend has been arrested. Friend is detained without lawful justification. Information should be given within how many hours? 48 hours. How many hours? Clear with this time limit to supply the information, correct, right? Within how many days? Generally 30 days, 35 days, 40 days, 48 hours. Next one, what if application is rejected? What is rejected? Application is rejected. Who reject the application form? Information officer. So if the officer shall communicate to the person making the request, if you reject the application form, you have to communicate to the person who makes an application the reason for rejection. Reason for what? That I can go for an appeal. Right? You need to provide the reason for the rejection, the period within which the appeal against such rejection may be what? Preferred. Within what time I can prefer an appeal for the rejection. And last one, particulars of appellate authority. What authority? Appellate authority. All these things to be what? Disclosed. Who should communicate all these things? Information officer. What officer? You need to provide what? Reason for rejection. Reason for what? Rejection. Second one, the time period. What period? Time period within which such application against such rejection may be preferred, and the particulars of authority. Appellate authority. Authority? Appellate authorities. Now, who are the appellate authority? To whom we can prefer an appeal. Prefer a what? Appeal. Don't turn the pages here. I know I have made it in an order wise. What wise? Order wise. It is different from what you guys are referring. This gives much more conceptual clarity, and this help you guys to remember the provision. Right? Yes or no? Yes. Appellate authority. What authority is? Appellate authority. First appeal. What appeal? If the public information officer or a state public information officer refuses to provide the information, we can go for a first appeal. First appeal is what to the applicant agreed by decision of PIO can appeal against it to the what? Departmental appellate authority within how many days? 30 days. First appeal shall be disposed within how many days? 30 days from the date of receipt, or within extended period of how much? 45 days. See, if I make an application to assistant public information officer, I can go to the public information officer as a what? First appeal in the department itself. What itself? For example, in the ROC itself, there will be a appellate authority. What authority? Against the public information officer, I can go to the departmental appellate authority. Authority? Departmental appellate authority. That is the first appeal. What appeal? Within how many days? 30 days. If you're not happy with the decision of the first appellate authority, then you can go for what appeal? Second appeal. See, we have CIO and SI. Central Information Commission and State Information Commission, SIC and CIC, which look after the implementation of Right to Information Act. Which Act? Right to Information Act. And they have a power to hear the appeal against the public information officers. They have a power to make the rules and regulations for the enforcement of which act? RTI Act. Who has the power to make the law? CIC and SIC. At the same time, CIC and SIC has a power to hear the appeals as well. Clear? So, any person aggrieved by the order of the first appellate authority can go to whom? CIC or SIC. CIC or what? If it is State Department, SIC. Central department, CIC. For what appeal? Second appeal. What appeal? Within how many days? 90 days of such date on which decision was given by the first appellate authority. Delay may be condoned by what? Appellate authority if sufficient cause is shown. What is shown? Sufficient cause is shown. Clear with this? Then comes third party appeal. What appeal? Now, what is third party appeal, sir? Really a different concept. Third party appeal means whenever a person seeks the information about the third party. What party? The third party who does not want to disclose his information can go for a what? Appeal. Go for a what? Third party appeal applies when the PIO discloses information that affects which party? Third party's interest. What interest? Third party can prefer an appeal against the PIO within how many days from the date of 30 days before the first appellate authority and second appellate authority within how many days? 90 days. How many days? I sought information about Nivedita. Now she can go for what? First appeal. What appeal? Sorry, first appeal. She's a third party, right? I am the one who's seeking the information here. She is a public authority. But you can go for a what? Appeal if you don't want that information to be disclosed. First appeal to the department authority. Second appeal to whom? CICR, SIC. CICR what? That is called as third party appeal. What appeal? Generally, citizen, the one who make an application, go for an appeal. But if I saw third party information, if you're against the disclosure of information, you can also go for an appeal. That is called as what appeal? Third party appeal. Are you guys clear with the procedure for obtaining the information and how to prefer an appeal? How to prefer the what? Appeal. Are you guys clear with this? Yes or no? Next, we have what? Information exempt from disclosure. Important based on this, they ask questions many times in the previous examination. What information? Bolo? Bolo na? What informations are exempt from what? Disclosure. Following informations are exempt from what? Disclosure. Under which act? RTA Act. Which act? Information whose disclosure could prejudicially affect the sovereignty and integrity of what? India. Security, strategic, scientific, and economic interest are relation with what state? Foreign state. So if it affects the sovereignty and integrity of India, such type of information may not be disclosed. Second one, information forbidden to be published by whom? Any court of law. For example, court secrets. The information which are given in a sealed cover cannot be disclosed. Next one are which constitute a contempt of court or violation of orders of the court. Next one, information that would breach the privilege of parliament or the state legislature, which is disclosed only to the parliament. Next one, information with respect to what? Commercial confidence, trade secrets, IPR rights would harm the competitive position of what party? Third party may not be disclosed. Next one, information that is what? Confidential and obtained from which government? Foreign government may not be disclosed or exempt from disclosure. Next one, information whose disclosure endanger the life or physical safety of whom any person or identify sources of what? Information about the one who gives information about the accused or we give witnesses, those names may not be disclosed. Next one, information that affects the ongoing investigation. What investigation? Ongoing investigation. Next one, cabinet papers. What paper? Whatever discussion happens in the cabinet may not be disclosed. It is exempt from disclosure. Correct, right? Now there is a discussion going on in the cabinet with respect to the Pahalgam terror attack. Can you seek such information? What is going on between the in the cabinet? No. Next one, information with respect to the personal information. What information? Whose disclosures has no relation to what? Any public activity or interest or which would cause unwarranted invasion of what? Privacy of an individual. Right? For example, disclosure about my medical records, my income tax details. Can you seek such a type of information? No. Why are you concerned about my medical records? That's a breach of privacy. Clear with this? These are the informations which are exempt from what? Disclosure. They may ask practical question based on this concept. Okay? Next one. Power to receive complaint by whom? CIC and SIC. They are the one who oversee the implementation of RTI Act, right? So they can receive the complaint from whom? Citizens. From whom? Citizen. On what grounds? Listen, everybody. CIC or SIC has the power to receive the complaint from whom? Following person. What person? What is the first one? The person who has not been able to submit an information request become because a PIO has not been appointed or who has been refused information that was requested. That was what? If PIO is not there in the public authority, how will I seek information? I can go to the CIC saying that appoint PIO because I need information. I have a right to seek information. Or what if they reject my application form? Can I go to CIC or SIC? Yes. Who has received no response within the what time? I can go to whom? CIC or SIC. Who thinks fees charges are what? Unreasonable. I can go to SIC or CIC. Next one. Who think information given is what? Incomplete, false, or misleading. And any other matters with respect to obtaining the informations. For these, I can go to whom? SIC or CIC. Bolo? SIC or CIC. They may ask this question. For what reasons a person can complain or give a or for what on what matters the SIC or CIC can receive the complaint. SIC can receive the complaint or CIC can receive the complaint that public information officer is not appointed or rejected the application or has not given the information within the what time? Prescribed time. What time? Next one, penalties on PIO. What is the penalty applicable? Fine of rupees 250 rupees per day. Maximum how much? 25,000 rupees. For what? Non accepting the application, delaying the information release without reasonable cause, malafidely denying the information with bad intention, knowingly giving incomplete, incorrect, misleading information, destroying information that has been requested, and obstructing furnishing of information in what manner? Any manner. Correct, right? Yes or no? Understood? In this situation, there is a fine of how much? 250 per day. Maximum how much? 25,000. Then we have a case law, Central Information Commission, CIC versus what? DDA. See what happened in this case? The power of CIC to form benches to hear the appeal was challenged in the High Court, saying that the CIC does not have the right to form the benches. You know what is benches? Benches means where the hearing happens. We have only one NCLT. Agree with this? How many NCLT we have? In entire India, there is how many NCLT? Hmm. There is only one NCLT, but NCLT has benches all over India. Bench is different, NCLT is different. See, we have High Court of Karnataka. Only one High Court of Karnataka is there, but the bench is in Kalburgi also because they cannot come to Bangalore, right? The distance is too much, right? So hearing happens even in Kalburgi also. Correct, right? Rahayana, clear with this? So there was a question, there was a case in which they challenged the power of the CIC or SIC to formulate what? Benches, and Supreme Court held that as a regulator and for effective implementation of RTA Act, CIC has the power to formulate what? Benches. Clear? So the CIC's power include all necessary measures to effectively manage its what? Affairs, including form what? Forming the benches to handle an increasing volume of cases. What of cases? Volume of cases. Because there are more volume of cases, the benches can be formed by whom? CIC, Central Information Commission. This is what held in which case law? DDA and others case law. Next one, powers of Information Commission. What it can do? It has a civil court power. What power? Have I discussed the concept of civil code power, the powers of civil code, enforcing the attendance of any person, discovery of documents and inspection of documents, and receiving evidence on what? Affidavit, requisitioning any public record, copies, or issuing the summons for the what? Examination of witness or documents. Clear with this? Yes or no? With this, we are done with what? Right to Information Act. Tell me, if a person seek information concerning the life or liberty of a person, the information should be given within how many hours? 14 hours. How many hours? Clear with this? Let's solve the questions with respect to what? RTI Act. Which Act? RTI Act. Chapter number क्या है? 14. Chapter number 14. Simple chapter. You can aram se score good marks based on this. Huh. Explain the salient features of RTA Act. Features of RTA Act extends to whole of India. Provide time limit for commencement of the Act. Apply to public authorities. It provides the right to seek information and appointment of public information officer and state public information officers. Fees will be payable by the applicant. Certain category of informations are exempt from the disclosures. All these things you write in the examinations. Next one. In RP Limited versus Indian Express newspaper, Supreme Court read Article 21, the right to know. What to know? Right to know is a part of what? Right to life and liberty. Right to know, right to impart information is also part of right to life. Right to what? Life and personal liberty. Uh, Next one, obligation of authorities, public authorities. Every public authority has the right to disclose certain informations voluntarily with about their organization, powers, rules followed, all these things. These are all voluntary disclosure. What disclosure? Voluntary disclosure. This should be done within how many days? 120 days. In the date of commencement of the act, at the starting stage of enactment of the act. Request for obtaining information. You have to make a request. How to make a request? Have I discussed? Application to authorities, time limit, fees to be paid. What happens if there is a rejection of application? All these things we have discussed in detail. Correct, right? You have to, as I said, you have to write the answer according to the weightage of the question. Weightage of the what? Question. Exemptions from disclosure. Can you guys read this Amar case law, please? Read Amar case law, everybody. Amar is a citizen of India and lives in Delhi with his family. He makes an application to the Public Information Officer under the Right to Information Act and complete all the formalities. The information sought relates to the cabinet papers, deliberations of the Council of Ministers. The PIO rejects the application. Has Amar any right to go to the court or the Central Information Commission against decision of the PIO? Where he can go to the central information. Uh-huh. Oh, it's exempt from what? Disclosures. Very good. Cabinet papers are exempt from the disclosure. Okay? But you have to write all the points. Remember, even though question is with respect to only one part, you write all the information which are exempt from disclosures. Clear? Short notes will help you guys to remember the points. Then next one. Uh, Constitution of what? Central Information Commission. What is the composition of the CIC and SIC? I have given this question. Just go to it. Theory question. Information Commission. Rights of which commission? Information Commission. Civil Code power. What power? Civil Code power. Appeal. Can you guys read this question, please? Vimal made an application in writing with a prescribed fees to be the public information officer, obtaining the information which is permissible under the relevant statutes. The PIO neither provided the required information nor rejected the application of Bimal for providing the required information, although a period of 45 days elapsed from the date of submitting the aforesaid application to the PIO. Bimal wants to file a suit in the civil court for not providing the required information to him. Advise Bimal. Will Bimal succeed? Can he go to civil court? No. He has to go to what? CIC. CIC. Can I try officer senior to the rank of what? Central or state public information officer. First departmental appeal, na? First departmental appeal. Then to CIC or SIC. First appeal is always to what? Departmental, senior in the department, appellate authority. Then to CIC or SIC. That is second appeal. What appeal? Second appeal. Explain the provisions for appeal. First appeal, second appeal, and third party appeal. What appeal? Time limit. Can you guys write the answers for this question? Next one. Rajendra Singh. Below was this is with respect to the age of appointment. What is the maximum limit for appointment as a member of CIC? 65 years. How many years? 65 years. Uh, Penalties 250 per day, 20,000 rupees for certain offences. Correct, right? See, we are in a position to answer all the questions because we're not doing selective study here. We are studying everything. Even though it is a rapid revision, we are covering all the concepts of the act, except the topics which are not relevant. But those topics I have discussed in detail while studying in the class. Okay, done. So with these, we are done with what? Right to Information Act, RTICS. Next, let's start with right to lesson 15, law relating to information technology. This act deals with electronic transactions, electronic devices, and computer related offenses. There are few instruments or documents for which IT Act is not applicable. Which act is not applicable? IT Act is not applicable. What are those documents or the transaction to which the IT Act is not applicable? First one, negotiable instrument. What instrument? Other than check. Check can be in what form? Electronic form. What form? Electronic form. Power of attorney. When you appoint an agent to act on behalf of you, that power of attorney cannot be made in what form? Electronic form. What form? Electronic form. Next, a trust. Present? Trust. A trust deed cannot be executed in what form? Electronic form. What form? Electronic form. So for trust deed, IT Act is not applicable. Next one, will or any other testamentary disposition. What is testamentary disposition? After the death of the person. Cannot be, IT Act is not applicable. Next one, any contract for the sale or conveyance of immovable property or any interest in such property. Sale of immovable property, what is not applicable? IT Act is not applicable. You cannot make the contract in electronic form. Any other class of documents notified by which government? Central government. What government? Central government. These are the documents which are for which what is not applicable? IT Act is not applicable. What is the first one? Negotiable instrument. Second one, power of attorney. Third one, trust. Fourth one, will or any other testamentary disposition. Fifth one, sale of immovable property, any other class of documents notified by central government. Important and based on this, they ask question many times in the previous exam. Next one, digital signature and electronic signature. What is digital signature, sir? Means a valid method of authentication. The authentication is to be affected by what? Use of asymmetric crypto system. What is asymmetric crypto system? Which consists of as function, that is, it includes two keys, private key and public key. Private key and what? Public key. We have DSS, digital signature certificate, which are used to authenticate the document. Authenticate the what? Document. Then we have electronic signature. What signature? Electronic signature. It is a digital form of web link. What link? Signature that is legally binding and to secure the what? Legally binding and secure. It is used for what? Verifying a document. What of a document? Verifying a document. Tell me which signature is used for verifying a document? Electronic signature. What signature? Electronic signature. Reliability of Reliability criteria for electronic signature. What signature? Electronic signature. An electronic signature is considered to be reliable if it satisfies the following five conditions. What is the first one? Linking. The signature creation or authentication data must be linked to the signatory, that is the one who signs it. Second one, the data must be under the what? Control of signatory at the time of signing and not accessible to whom? Anyone else. Third one, any alteration to the electronic signature or the signed information after affixation must be what? Detectable. So only it is called as what? Reliable electronic signature. So after signature is made, any tampering or change should be easily detectable. Next one, Detectability of what? Information alteration. Any alteration to the content of the record after authentication by electronic signature must be what? Detectable. Must be what? Detectable. Other prescribed condition, the central government may prescribe additional conditions for what constitutes a reliable electronic signature or techniques or what? Techniques. Clear with this? So these are the conditions to be satisfied to consider a signature as what signature? Reliable electronic signature. Next one we have e-governance. Important based on this they may ask question in the examination. What is e-governance? Electronic or e-governance. What governance? Electronic or e-governance means functioning of the government with the use of the informations and communication technology. Functioning of the government with the use of information and communication technology, where any document required to be writing or typewritten form or printed form, then such requirement is satisfied if such information or matter is rendered or made available in what form? Electronic form and accessible so as to be usable for subsequent reference. What reference? It is called as what? E-governance. What governance? E-governance. E-governance means functioning of the government with the use of what? Information and communication technology, where various government services are available through what? Electronic communication media. What communication media? Electronic communication media. Next one, validity of the contracts formed through what? Electronic means. Tell me, any contracts which are made through electronic communication media, valid or not valid? Valid. Even exchange of emails, exchange of what? Emails are considered as what contract? Valid contract. We have discussed arbitration agreement. What agreement? Can arbitration agreement be in the written form? Yes. And a document is deemed to be in written form, even if there is an exchange of what? Mails, telecommunications. Correct, right? Sorry, not telecommunication, any electronic communications media. Next one, certifying authority. See, to obtain the DST, obtain the what? We have a certifying authorities. See, we have the controller of certifying authorities, CCA. CCA, CCA what? Gives the power to whom? Power to the certifying authority. What authorities? Certifying authorities. These are the one who issues what? Digital signature certificate. Follow? Digital signature certificate. If you want DSC, you'll apply to whom? Certifying authorities. We have certifying authorities like eCifi, eMudra, Geo. All they provide, all these companies provides what? Digital signature certificate facilities. What facilities? What facility? Digital signature certificate facility. Revocation of digital signature certificate important they may ask in the examination in what cases the government can remove the digital signature certificate. What is the first one? On the receipt of request by whom? Subscriber or any other person authorized by him. On the death of whom? Subscriber. Death of whom? Death of whom? Subscriber. They can revoke the digital signature certificate. Next one, dissolution of the partnership or winding up of the company. When company is not there, where is the use of digital signature? Next one, material fact represented in the digital signature certificate is false or has been what? Concealed. A requirement for issuance of digital signature certificate was not satisfied, or the certifying authority's private key was compromised. There is password has been leaked. In that situation, who can remove the digital signature certificate? Certifying authorities. Or the subscriber has been declared what? Insolvent or dead. Cyber Regulation Appellate Tribunal. The central government shall specify by notification the matters and the places with respect to which appellate tribunal. What tribunal? May exercise the what? Jurisdiction. Any person aggrieved by an order of the controller of certifying authorities or of the adjudicator can appeal to whom? Appellate tribunal. What tribunal? Within how many days? 45 days. How many days? Are you guys clear with this? And against that, you can go to which court? High Court. Within how many days? 16 days. Clear with this? And these are the important provision. What provision? Important provision. With respect to which act? IT Act. We will cover the remaining provision with the help of the word question bank. Let's go to the question bank. I'll tell you guys what are the important question which may be asked in the examination. Let's start. Question number one. IT Act does not apply to what document? Certain documents are transactions. Explain. Can you explain? Next one, definitions. Distinguish between what key? Public key, private key, and key paid. There is this question in the which examination? 2009 examination. Clear? Private key, public key, and key paid. What pair? Key paid. Distinguish between what? Computer and computer network. Definition of computer and computer network. What is computer network? Interconnection of computers is called as what? Computer networks. Huh. Distinguish between what? Electronic form and electronic record. Electronic means information generated, sent, received, stored in media, magnetic, optical, computer memory, microfilm, microfiche, or similar device. What is electronic record? Data, record, or data generated, or image or sound stored, received, sent in the what form? Electronic form, microfilm, computer generated, microfiche. It is called as what record? Electronic record. Digital signature and what signature? Electronic signature. They asked this question in the previous examination. Difference between what signature? Electronic signature and what signature? Digital signature. What signature? Digital signature. Next one, what do you mean by electronic signature certificate under the IT Act? Discuss the procedure to obtain the what? Electronic signature certificate under the what? Act. How we can obtain? You should make an application to whom? Certifying authority. What authority? Certifying DSC. Same thing is there even in your company's act also. Next one, electronic governance. Can you write a short note on electronic governance, e-governance? Yes or no? Certifying authorities. When certifying authority can revoke the DSC. Death of the subscriber, dissolution, then declared to be what? Insolvent, or dissolution of the partnership firm, or winding up of the company. Under what condition digital signature may be suspended by whom? Certifying authority. What authority? Suspension is different, revocation is different. When suspension can happen? Subscriber listed in the digital signature certificate or any person duly authorized to act on that behalf make an application for suspension. Or it is of the opinion that digital signature certificate should be suspended. Who can certify it? Who can suspend it? Certifying authority. Question number three. Question number three. Under the Information Technology Act, Controller of Certifying Authorities issued an order on 1st April 2023. Deepak received the certified copy of the order on 3rd April 2023. Deepak is dissatisfied with the decision issued by the Controller of Certifying Authority and subsequently filed an appeal on 3rd May 2023 against this decision to the appellate tribunal. Examine the validity of the what? Appeal. Within how many days? 45 days. To High Court? 60. Question number one. Question number one. Read question number one. decide with reference to the provisions of relevant statutes. It is called as what? Hacking and tampering of tampering with the computer resources. What resources? Computer resources. Uh, that is not important. This question is important. Liability of whom? Network service provider. Who is network service provider? These intermediaries are there, right? Facebook, Google, Instagram. They provide the platform for sharing the information. Are they liable for any information shared in their platform? If it happens with knowledge, they would be responsible. Otherwise, they're responsible, not responsible. Not responsible. This question is also important. Question number two. Does section number 79 of IT Act, as originally enacted, deal with the effect of other laws or not? Answer in the light of recent decision by the Supreme Court of India in the case of what? Google India Private Limited versus what? Vishaka Industries and others. Section 79 as originally enacted provided immunity to whom? Intermediaries. Intermediaries means who? The one who provides the network service. What service? But did not extend to offenses under the what? Other laws, such as defamation under the section number 356 of the BNSS. High Court's finding that Google India failed to act did not change the fact that section number 79 had no bearing on the liability under the what? Other laws. Section 79 as originally enacted did not exempt intermediaries from the what? Liability under which laws? Other laws, including defamation under the what? BNSS. You may not be liable under the IT Act if you have taken a reasonable care. But under BNSS or BNS for defamation, are you liable or not liable? Liable. Exemption from IT Act will not exempt you from which act? Other laws. Other what laws? Other laws. If somebody posts a defamatory matter in your platform, and even after it is notified to you, if you don't take it down or if you don't remove it, are you punishable? Not punishable. Punishable. Under which act? BNS. Bharatiya Nyaya Sanhita. Just because you are exempted under the IT Act, it doesn't mean you are also exempted under which act? BNS. Clear? Next one. Cyber Appellate Tribunal, 45 days and 60 days. And this one is important. Question number one. Data privacy and protection in today's world has become a matter of what? Individual rights. Discuss the rules defining the sensitive personal data. Important. What is called as sensitive personal data? Passwords, account details, credit card details, present and past health records, sexual orientation, biometric data. All these are called as what? Sensitive personal data. Other topic, list 8 act done without permission of the owner, liable for what? Damages. You can go through it. And this one is also important. Mm, to secure the electronic record. This is also important. Question number 4. What is the purpose of Digital Personal Data Protection Act 2023? Newly introduced. They may ask this question in the examination. Question number 4. Question number what? 4. Important. Mark it important. Based on this, there may be a question in the examination. Mark this question as important question. Important what? Question. The object of which act? Digital Personal Data Protection Act, which year? 2023. Which year? 2023. Clear with this? So with these, we're done with what? Information Technology Act. Done? Chalo. Lesson 16, Contract Law. What law? This act is all about contracts, general principles of contract, as well as the special contract. You have both general principles as well as the special contract. 1 to 75 provides the what? General principles of contract. 124 to 38 provides one special contract. 1 to 75 general principles of contract. 124 to 238 special contract. Correct, right? So now I hope you guys remember what I taught in the previous classes, like offer plus acceptance, promise, promise plus consideration, agreement, agreement plus enforceable by law, contract. I'll not get into the basic concepts because it is a rapid revision of jurisprudence interpretations and general laws. Right? So let's discuss the important topics of the Indian Contract Act 1872. Which act? Indian Contract Act 1872. First one is what? Offer. What is offer? What is offer? In case of offer, there will be how many parties? Two parties. Listen, everybody. Every contract starts with what? Offer. Offer plus acceptance becomes what? Promise. Promise plus consideration becomes what? Agreement. Agreement plus enforceable by law becomes what? Contract. Correct, right? So offer accepted becomes a promise. Promise having consideration becomes agreement. Agreement which is enforceable by law becomes what? Contract. Let us discuss one by one in detail. What is the first one? Offer. What is offer? What is offer? When one person signifies his willingness to do or abstain from doing anything with the intent to obtain the assent of which person, other person is said to make an offer. It is also called as a proposal. Called as what? Proposal. Section 2, subclause A defines the word what? Offer. What is offer? When how many person? One person signifies his willingness to do or abstain from doing something with the intent to obtain the assent of which person, other person is said to make an offer. The one who makes the offer is called as what? Offerer. Other person is called as what? Offeree. There will be how many parties? Two parties. Types of offer. What is the first one? Particular offer. What offer? What is particular offer or specific offer? If an offer is made to an identified person, it is called as what offer? Particular offer or specific offer. Next one is what offer? General offer. What offer? If an offer is made to the public at large, or the general public, it is called as what offer? General offer. What offer? I repeat, if an offer is made to an identified person, it is called as what offer? Specific offer or particular offer. If offer is made public at large, it is called as what offer? General offer. So who can accept general offer? Anyone who is aware about the offer can accept the general offer. Next one is cross offer. What offer? What is cross offer? Exchange of similar offers or identical offers by the parties without the knowledge of each other's offer. It is called as what offer? Cross offer. What offer? Cross offer. Next one, open, continuous, or standing offer. If an offer is made to remain open for a specific period of time, during which the offer can be accepted more than once, it is called as what? Open offer, standing offer, or continuing offer. I repeat, if an offer is kept open for a specific period of time for its acceptance, it is called as what offer? Standing offer. What offer? Standing offer. Last one, counter offer. What is counter offer? If an offeree gives the qualified acceptance or a conditional acceptance to the offer, subject to modification or variations in the original offer. What offer? I made an offer to sell the goods to you at 100 rupees. You reply saying that no, I will buy at 75 rupees. It is called as what offer? Counter. These are the various types of offer. A counter offer lapses which offer? Original offer. A counter offer amounts to rejection of the original offer. What offer? Original. Clear with this? Next, what do we have? Acceptance. What do we have? What is acceptance? Person to whom the offer is made, he signifies his assent to the offer. It is called as what? Acceptance. Means when he say yes, it is called as what? Acceptance. Correct, right? Rules of acceptance. It may be expressed or implied. What do you mean by expressed? By words. What do you mean by implied? Other than words, by action or conduct. It is called as what acceptance? Implied acceptance. What acceptance? If the mode of acceptance is prescribed, acceptance shall be given in the what mode? Prescribed mode. What mode? If the offerer specifies that the acceptance should be given by letter, you must give acceptance by what? Letter. Telephone, telephone. Acceptance must be unqualified and absolute. Unqualified and what? Absolute. What is unqualified? without any condition. Because if you put conditions or if you give an acceptance subject to conditions or modifications of the original offer, that amounts to what offer? Counter offer, not a valid acceptance. Clear? Next one, counter offer or conditional acceptance operates as a what? Rejection of the offer. Rejection of what? Offer. Acceptance must be absolute. Acceptance must be communicated to whom? To the offerer. Who should communicate the acceptance? Offeree. To whom? Offerer. Below, who should communicate? Offeree. To whom? Offerer. Mere silence does not amount to what? Acceptance. The offerer cannot presume the acceptance by silence. But however, you can presume the rejection by silence. What by silence? Rejection by silence. Next one, if the offer is one which is to be accepted by acted upon, no communication of acceptance to the offerer is necessary. Means if an offer is required to be accepted by performing the conditions of the offer, generally the general offer, what offer? A general offer can be accepted by performing the what of the offer? Conditions of the offer. What of the offer? Conditions of the offer. So if an offer can be accepted by performing the conditions of the offer, what is not required? Express communication is not required. Next one. The acceptance must be given within what time? A reasonable time. What time? And before the offer lapses. These are the essentials of what acceptance? Valid acceptance. What acceptance? Valid acceptance. Then we have consideration. Offer plus acceptance becomes what? Promise. And a promise having consideration becomes an agreement. Becomes what? Agreement. Now, what is agreement? Sorry, what is consideration? Simple. Consideration means something in return. What in return? Something in return. What is consideration, sir? When at the desire of whom? Promiser. So consideration must always happen at whose desire? Promiser desire. Whose desire? So when at the desire of the promiser, promisee or any other person who promising or any other person, either he has done something or he has does something or abstain from doing something or promises to do something, such an act or abstinence or a promise is called as what? Consideration. It can be past, present, as well as future. Listen everybody. See, what is consideration? When at the desire of whom? Promiser. Consideration must happen as per whose desire? Promiser desire. When at the desire of the promiser, promisee. Promisee can do or any other person can do. Promisee or any other person done or abstained from doing. Means what? Past. Done means what? It's already done, right? Past. Done or abstained from doing. What is abstained? Negative. Consideration can be positive as well as what? Negative. To do something or abstain from doing something. Abstain from what? Doing something. Correct, right? Yes or no? So, if a person has done or abstained from doing or does or abstains from doing, what from doing? Abstains from doing or promises to do. What to do? Promises to do or to abstain from doing such an act or abstinence or a promise is called as what? Consideration for the promise. What for the promise? Consideration for the promise. Are you guys clear with this? What is consideration? When at the desire of the promiser, promisee, or any other person, done or abstain from doing, thus or abstains from doing, or promises to do or abstain from doing something such as act or abstinence of the promise is called as consideration for the promise. Consideration for the what? Promise. Clear with this? Next, we have types of consideration. It can be executory, executed, as well as what? Past. What is executory? If it is a promise to be performed on a future date, it is called as what? Executory. What is executed? Act or the forbearance made or suffered. It is called as what? Executed. What is past? The past act or the forbearance is called as what? Past consideration. What consideration? Past. If it is already done or abstained before the contract is made or promise is made, it is called as what? Past consideration. What consideration? Past consideration. So consideration can be executory, executed, or it can also be what? Past. Next one, rules of consideration. What of consideration? What are the rules of consideration? Every promise must be supported by what consideration? Valuable consideration. There must be a consideration for every promise. A promise without a consideration, valid or not valid? A promise without consideration, valid or not valid? Not valid. Not valid. A consideration may be an act or an abstinence or it can be a promise. What is act? Doing something. What is abstinence? Not doing something. What is a promise? Promise to do something. Future consideration. There must be a mutuality. What is mutuality? In every contract, there will be how many promises? Two promises. Every promise must be supported by what consideration? Valuable consideration. Clear with this? Next one. Uh, it must be real. What must be real? Consideration must be real and not vague, indefinite, or illusory. Indefinite or what? Illusory. Consideration need not be adequate. What need not be adequate? Consideration need not be adequate. Consideration must be lawful. What must be lawful? Consideration must be lawful. What must be lawful? Correct, right? It should not be opposed to public policy. It should not be considered as unlawful. Next one, consideration must be something more than the promisee already bound to do. For whom? Promiser. Bound to do for whom? Promiser. If something, for example, हम लोग डिस्कस किया था ना where a postman, remember, a postman made a promise to deliver the letter for an extra consideration. Is it valid or not valid? Not valid. Why? Because delivering the letter is already an obligation as per the law. Correct, right? And even the government officers, if they take money for performing certain activities, is it valid or not valid? Not valid. Clear with this? Next one, exception to consideration. Exception to what? What is exception to consideration? What is exception to consideration? Agreement without consideration, valid or void? Void. Generally what? But are there any exceptions? Yes. What are those exceptions? First one, agreement made out of natural love and affection, provided the agreement is in what form? Written form, registered. Between relatives, out of what love and affection? Natural love and affection. Second one, past voluntary services. What services? Past voluntary services. If it is, it can be in oral form or it can be written form. If somebody has given services to you voluntarily, not a valid consideration, but however, if you make a promise to pay for the same, is it valid or not valid? Valid. Next one, time bar. What bar? What is time bar? After the expiry of how many years? 3 years. If a debt is time barred, what is time barred? Debt is time barred in that scenario. But if there is a promise to pay a time barred debt, if there is a new contract, is it valid or not valid? Valid, enforceable by law, even though there is no consideration. Next one, agency contract. What contract? Agency can be with consideration or without consideration. If a person get a commission or remuneration for his work, it is called as what? With consideration. But however, agency can be what? With the consideration or without consideration. Both are valid. Next one, completed gift. What is completed gift? It's a gift where what is transferred? Possession is transferred. What is transferred? Donor has already transferred the possession of the gift to whom? Donee. Is consideration required or not required? Not required. Next one is what? Charity. Next one is what? Charity. Charitable agreements does not require what? Consideration. Does not require what? Considerations. Correct, right? If a person promises to give a charity, not valid. But however, a person has promised to give a charity, and based on the promisee has done something. Who has done something? Promisee. Is it a valid or not valid? Valid. See, I made a promise to give a donation of 1 lakh to a temple. Based on that promise, the temple has incurred some expenses like buying some construction material or doing some work. Now, is this promise enforceable? Not enforceable. Enforceable. Why? Because based on the promise has done something. Yeah. So these are the exceptional cases where even though there is no consideration, the agreement is enforceable by law. What is the general rule? Any agreement without consideration are void, not enforceable by law. But are there any exception? Yes. Natural love and affection, past voluntary services, time barred debt, agency, completed gift, and charity. Clear with this? Next, we have privity of contract. What of contract? Privity of contract. You know what is privity of contract? Contractual relationship. See, contract is a private relationship between the parties. Only a party having contractual relationship can enforce the right available out of a contract. Correct, right? For example, if there is a contract between X and Y, who can file a case? X can file a case against Y. Y can file a case against the X. Can a stranger or a third party interfere between the parties to a contract? No. That is called as what? Privity of contract. Because a contract neither creates a right nor imposes an obligation upon whom? Third party. It only creates a right between whom? Parties to a contract. What is the contract? Parties to the contract. However, there are exceptional cases where even though a person is a stranger, can still enforce the right available out of the contract, or he can enforce the rights out of the what? Contract. That is called as what? Privity of contract. What of contract? Privity of contract. What is the privity of contract? Exception to privity of contract. What is the first case? In case of beneficiary of a trust. Beneficiary of what? Trust. Remember, there will be a contract between whom? Testator and trustee. Testator and what? There will be a contract between testator and trustee. Correct, right? But who can enforce the contract? Beneficiary. Even though beneficiary is a stranger, who can enforce the contract? Beneficiary can enforce the contract. In case of assignment of contract, what of contract? Who can enforce the contract? Assignee can enforce the contract. An assignee under an assignment made by the parties are by what? Operation of law. What of law? Operation of law. In case of family arrangement, what arrangements? Or settlement between the male or female members of a Hindu family. Who can enforce it? Family members can enforce it. Who can enforce it? We have discussed this concept even in case of this specific relief act. Which act? Specific relief act. Which act? Remember where family settlement, one of the family member can specifically enforce the contract. Next one, in case of acknowledgement of liability. Remember I gave an example of agency. Example of what? Agency. If I have a contract, listen everybody. If I have a contract with Mr. X, let's say X made a contract with Y. Now, who is the debtor? Y is the debtor, X is the creditor. If Y defaults, who can file a case? X can file a case. Who can file a case? X. Now, what happened? Mr. Y appointed Mr. Z to hand over the money to whom? Mr. X. So, Mr. Z is acting as whose agent? Whose agent? Y's agent. Whose agent? Y's agent. Who is the agent of whom? Z is the agent of whom? Y. Correct, right? Now, if Z defaults in making the payment to Mr. X as per whose instruction? Y instruction. Who can file a case against Z? Y. Can X file a case? No, because there is no what? Privity of contract. There is no what? Privity of contract. But however, what if Mr. Z admits the liability to Mr. X? In that scenario, can X file a case? Once Mr. Z admits his what? Liability to whom? X. If he calls and informs Mr. X, I admit that I'm liable to pay you. In that situation, can X file a case against Mr. Z? Yes. That is called as what? Acknowledgement of liability. What of liability? Acknowledgement of liability. And the last one is what? Covenants running with the land. What running with the land? Covenants running with the land. You know what is covenant running with the land? Any conditions imposed on the land always runs with the what? Land. Even the subsequent buyer. What buyer? Subsequent buyer are bound by the conditions imposed on the what? Land. For example, I have a contract with one of the neighbor person who owns the property which adjacent to the my property. The condition is that we should not construct more than one floor. We both have agreed to not to build more than how many floors? One floor. Now the neighboring person has sold it to someone else and he wanted to construct more than how many floors? One floor. Can he construct more than one floor? No. Why no? He is also bound by what? This condition. Because conditions always goes with what? Land. इसको बोलते हैं covenants running with the land. It's called as what? Covenants running with the lands. Tell me what is called as what? Covenants running with the land. Are you guys clear with this? What running with the land? Covenants running with the land. Next we have flaws in the capacity. What in the capacity? Flaw. What is flaw? What do you mean by flaws? Mistakes are the wrongs in the capacity. Means if the Person is incompetent to contract. Is that contract valid or void? Void. Enforceable, not enforceable? Not enforceable. Tell me, is a minor competent to contract, incompetent to contract? Who is a minor? The one who has not attained the age of what? Majority is called as what? Minor. That 18 years. We discussed this under the CPC also. Civil Procedure Code. What code? Civil Procedure Code. So minors agreement. What agreement? Any minors agreement. Is it any agreement with a minor valid or void? Void ab initio. What is void ab initio? Void from the beginning itself. Void from the what? What is beginning itself? Initial stage itself. Enforceable, not enforceable? Not enforceable. Can it be ratified after it becomes a major? No. Once void, always void. A minor's agreement cannot be ratified even after he becomes what? Major. Once void, always void. Next one, principle of estoppel. Applicable to minor, not applicable to minor? Not applicable to minor because a minor can always plead what? Minority. For example, if a minor misrepresents his age, what he does? Misrepresent the age and enters into a contract. Can he claim the minority? Can he claim the minority? Yes. He cannot be denied. He cannot be stopped from denying the fact that he's a what? Minor. Agreement is still void even though he had a misstatement because principle of estoppel not applicable to whom? Minor. Not applicable to whom? Minors. Clear with this? Next one. An agreement by a minor is what? Being void. Court will never direct specific performance. What performance? Specific performance. And one more. Is minor estate liable for supply of necessary item? What is necessary item? The items which are essentially needed. What needed? Essentially needed by the minor. It is called as what? Necessary item. What items? Necessary item. Is minor estate liable for the supply of necessary items? Yes. Minor is not responsible. His assets are responsible. If he has the assets, out of the assets, can the person who supply necessary item recover it? Yes. Next one, minor can be an agent. Who can be an agent? But it cannot be a what? Principal, nor can be a partner, nor can be a what? Partners. Next one, since minor is never personally liable, he cannot be adjudged as what? Insolvent. Who cannot be adjudged as an insolvent? Minor cannot be adjudged as an insolvent. Correct, right? Next one, an agreement by a parent or a guardian entered into on behalf of the minor is binding on him, provided it is for this what? Benefit as or is for a legal necessity. What necessity? Legal necessity. Right, right? Yes or no? So any agreement made by the guardian on behalf of the minor, valid or not valid? Valid. Valid or not valid? Valid. Clear with this? For the benefit of a minor. Benefit of what? Minor. But however, they cannot deal with immovable property. They cannot buy or sell the immovable property on behalf of the minor. That requires the permission of the court. Permission of the what? Court. Next one, lunatics. Who are lunatics? Unsound mind. Any agreement with unsound mind enforceable, not enforceable? Not enforceable. Void or voidable? Void. Not enforceable by laws. Correct, right? Who is unsound mind? The one who cannot understand the terms of the contract and cannot make what judgment? Rational judgment. What judgment? That person is called as what? Lunatic or unsound mind. Who are the persons of unsound mind? Is a lunatic. Person of what mind is a lunatic? Unsound mind is a lunatic. A lunatic or idiot or drunken or a person delirious from the fever or a person mental capacity is enfeebled by what age? Old age. What age? Old age. Other person qualified and disqualified from what? Contracting. Who are the parties disqualified from the law from entering into a contract? Alien enemies during the war. Opposite country citizens are considered as what? Alien enemies. Next one, foreign sovereigns because they're not subjected to the local jurisdictions. Next one, professional person. What person? Professional persons, but in India, professional persons can enter into a contract with a client and it is legally enforceable. Corporation, can company make a contract? Yes. Company is a what person? Artificial person. Can married women enter into a contract? Yes, there is no distinction in the Indian law or a contract between married women and unmarried women. Next one, flaws in the consent means the shortcoming in the consent. So if a consent is not free, there has to be a consent, right? Consent of whom? Both the parties. It must be a free consent. What consent? If the consent is not free, is the contract valid or voidable? Voidable. Contract is voidable. When the consent is not free, in case of CUFM square. Remember, what is C? Coercion. What is U? Undue influence. What is F? Fraud. What is M? Misrepresentation. What is M again? Mistake. So if there is a coercion, undue influence, fraud, misrepresentation, mistake, the consent is not free. If the consent is not free, the contract is valid or voidable? Voidable. At the option of how many party? One party. Who's that one party? The person whose consent is not free. One by one, what is the first one? Coercion. What is coercion? What is coercion? It is also called as what? Threat. All threats are not coercion. Only a threat which is forbidden by BNS. Forbidden by what? BNS. What is BNS? Bharatiya Nyaya Sanhita. Committing or threatening to commit any act forbidden by the Indian Penal Code or unlawful detaining or threatening to detain any property to the prejudice of any person, whatever with the intention of causing any person to enter into an agreement. Means if one person commits or threatens to commit any act forbidden by BNS or detains or threaten to detain any property unlawfully with the intent to induce the other person to enter into a contract or to give a consent to enter into a contract, it is called as what? Coercion. Called as what? For example, threat to kill somebody, threat to kidnap somebody, threat to not to release the salary unless until you give a consent for retirement or something. All these are called as what? Coercion. All threats are not coercion. Only the threats which are forbidden by what? PNS are called as what? Coercion. If there is a coercion, consent is free or not free? Not free. Consent is free or not free? Not free. Yes or no? Then we have undue influence. What influence? Undue influence. Section 16 deals with undue influence. What influence? Undue influence. What is undue influence? See, we can say there is an undue influence where there is a relationship between the parties. What between the parties? Relationship between the parties. The first condition is that there must be relationship between the parties. In that relationship, one person is in what position? Dominant position, and the one who is in dominant position takes the unfair advantage of his position. That is called as what? Undue influence. What influence? Undue influence. What is undue influence? Where the relationship between the parties is such that one person in a position to dominate the will of the other person and takes the unfair advantage of it. That is called as what? Undue influence. What influence? In case of undue influence, is the consent is free or not free? Not free. Consent is free or not free? Not free. Clear with this? And if there is no free consent, the contract is valid or voidable? Voidable. A person deemed to be in a dominant position in the following situation. What are they? If he has a real or apparent authority. If one person has an authority over the other person, the one who is having authority will be considered to be deemed to be in what position? Dominant position. What position? Dominant position. Next one is mental distress. What distress? What is mental distress? The person who is suffering from the mental incapabilities or unsound mind. So if there are two parties, one is sound mind, another one is mental person is suffering from mental distress. Now who will be in a dominant position? Normal persons. Correct, right? Having dominance is not wrong. Abuse of dominance or taking the unfair advantage of it is considered as what? Undue influence. What influence? Where there is a presumption of undue influence, the presumption can be reverted. Means what is reverted? Can be cancelled by showing that full disclosure of all material facts. What facts? All material facts are consideration what? Inadequate or the weaker party in receipt of what advantage? Independent advice. If you can prove that, then you can revert the presumption that there was a undue influence and the contract is valid. Even though you are a person at weaker position, you had an independent advice from an advocate or an expert. Then there is no question of what influence? Undue influence. What influence? Undue influence. Clear with this? So there must be relationship. One person in a dominant position and he takes the what advantage of it? Unfair advantage of it. Then it is called as what influence? Undue influence. Any transaction with Parda Nishin woman is also deemed to be what? Undue influence. There is no concept of perpetuity women now, but when the law was made, 1872, there were some women who never used to speak to the public. They used to live in a complete seclusion. They are called as what? Perpetuity women. What women? Perpetuity women. If you enter into any contract with perpetuity women, it is deemed to be what? Undue influence. What influence? Undue influence. Next one, unconsiderable transaction. What transaction? What is unconsiderable transaction? Unreasonable transaction. What transaction? Unreasonable transaction. If the terms of the contracts are unreasonable, are against the interest of only one party, then there is a presumption of what influence? Undue influence. For example, I'm charging an interest of 30%. How much? Reasonable or unreasonable? Unreasonable. There is a presumption of what influence? Undue influence. What influence? Clear with this? Next one, fraud. Next one is what? Fraud. Section number 17 defines the word what? Fraud. What is fraud? Suggestion as a fact. Suggestion as a what? Fact which is not true by one who does not believe it to be true. Does not believe it to be what? True. That is called as what? Fraud. Called as what? Fraud. What is fraud? Suggestion as a fact which is not true by one who does not believe it to be true. It is called as what? Fraud means a person makes a statement which is not true, even though he believes does not believe it to be true. Means he knows that whatever he's saying is false, not correct, but still he says that. It is called as what? Fraud. Called as what? Fraud. Next one, concealment of a fact. What of a fact? Concealment. Hiding a fact by one who is having the what? Knowledge or belief. Knowledge or what? Belief. It is also called as what? Fraud. Called as what? Fraud. A promise made. What made? Promise made without any intention of performing it. Without any intention of what? Performing it. It is also called as what? Fraud. Fake promises. I have given a lot of examples for all these concepts. Correct, right? Yes or no? Remember a promise made to a girl that he will marry. Boy made a promise to a girl to marry her without having intention to marry her. Is it called as a fraud? Yes, it's called as what? Fraud. Clear with this? You made a promise to sell, promised to grow and sell sugarcane within 3 months. How many months? 3 months or 4 months. Now it's almost 2.5 months. You did not even plant the samplings of the sugarcane. Is it a fraud? Yes, because you don't have intention of performing it, right? If you had intention of performing it, you would have planted the samplings, right? Yes or no? Is it a fraud? Making a promise without any intention of performing it is called as what? Fraud. Yes or no? What is the first situation? Suggestion as a fact which is not true by one who does not believe it to be true. Second one, concealment of a fact by one who having knowledge of or belief of it. Third one, promise made without any what? Intention of performing it. Fourth one, any other act fitted to deceive. Fifth one, such an act or omission as law specifically declares to be fraudulent. All these are called as what? Called as what? Tell me, does silence amounts to fraud? If a person is silent about something and if it does not disclose it, is it considered as a fraud? No. Mere silence does not amount to fraud. Are there any exception where silence also amounts to fraud? Yes. When a person has duty to speak, disclose all the information. If a person has duty to speak, but in that situation, if he remains silent, it is called as what? Fraud. Called as what? Example, in what type of contract you have a duty to speak? Insurance contract, prospectus, sale of land, and in case of what arrangement? Family arrangement. In these cases or in this contract, you have a duty to speak. What to speak? Duty to speak. Having duty to speak, if you don't speak, it amounts to what? But if it does not disclose all the material facts, it is called as what? Fraud. Called as what? Clear? Or where silence is itself is equivalent to speech. For example, if I say, if you do not deny it, I shall presume that this is of good quality. And if you remain silent, by remaining silent, you are admitting that it is of what quality? Good quality. If it turns out to be defective quality, are it punishable? Is it a fraud or not a fraud? Fraud. Clear with this? Next one. Fraud. Section number क्या है? 17. Next one, misrepresentation. What is misrepresentation? A innocent misstatement. What misstatement? Here the person who makes the statement does not have the knowledge of the falsity of information. What of information? Falsity of information. The one who makes the statement also believes that whatever he is saying is what? Truth. That is called as what? Misrepresentation. If a person makes a representation believing what he says is true, he commits what? Innocent misrepresentation. Below what representation? Innocent misrepresentation. Damages for innocent misrepresentation, generally no damages are paid. It is not paid, no compensation are paid in case of what? Misrepresentation, because the person is innocent here. But in case of fraud, aggrieved party can cancel and can also claim what? Damages. Claim what? Damages. Exception: a promoter or a director makes an innocent misrepresentation in a company prospectus inviting the public to what? Subscribe. Is he liable to pay compensation? Yes. In these cases, they may ask in the examination, in what exceptional cases a promoter is liable to pay compensation for what? Innocent misrepresentation. What is the first situation? Mistake in the, sorry, misrepresentation in the prospectus. Second one, against the agent who commits the what? Breach of warranty of authority. Means if it goes beyond the authority, who is liable to compensate? Agent. To whom? Principal. Or negligent representation made by one person to whom? Another person, between whom a confidential relationship like solicitor and client exists. That is advocate and client, are a CA and the client, and the CS and the clients, they have a what relationship? Fiduciary relationship. What relationship? And they have a relationship of confidence. Client imposes a confidence on the home. Professionals, correct, right? So in that situation, if there is any innocent misstatement by the professionals, are they liable to pay compensation? Not liable to pay compensation. Liable to pay compensation. Liable to pay what? Next we have mistake. Next we have what? Mistake. What is mistake? And what is mistake? Erroneous belief or a wrong belief about something or someone. It is called as what? Mistake. Called as what? If a parties have a wrong belief about something or someone, it is called as what? Mistake. Mistake can be of how many types? Two types. Mistake of law, mistake of fact. What is mistake of law? If you have a wrong belief about the law, it is called as what? Mistake of law. It can be of how many types? Two types. What are the two types? Mistake of foreign law, mistake of Indian law. What is foreign law? If you have a wrong perception about the word law applicable, foreign law applicable, it is called as what? Mistake of foreign law. Mistake of foreign law, the contract is valid. Mistake of Indian law, the contract, sorry, mistake of foreign law, the contract is void. Mistake of Indian law, the contract is valid. What is valid? Contract is valid. And what is valid? Contract is valid. Mistake of what law? Indian law. What law? Contract is valid or void? Valid. Mistake of which law? Foreign law. Why mistake of Indian law is valid? Because ignorance of law is no excuse. For example, a debt is time barred, but a person without having the knowledge of limitation act, he thought he is still liable to make a payment. So he made a new contract to pay time barred debt. Is he liable to pay? Not liable to pay. Liable to pay because the new contract is valid. Even though he had a wrong belief about the Indian law, the contract is still valid. Contract is still valid. Next one. Mistake of fact. Mistake about what? The terms of the contract. The mistake of fact can be classified into how many categories? Two categories. What is the first one? Unilateral mistake. Second one, bilateral mistake. What mistake? If both the parties are under mistake, it is called as what? Bilateral mistake. Contract is void. Contract is what? Void. If only one party under mistake, it is called as what? Unilateral mistake. What mistake? One party under mistake. The contract is valid or void? Valid. Bilateral mistake. If both the party under mistake, the contract is void. Contract is what? Void. One party under mistake, valid. Both the party under mistake, void. Right, right. Mutual or common mistake as to what matter? Subject matter. What matter? Subject matter. Mistake as to what? Existence of subject matter. Means I believe that the goods in existence, even the opposite party believes that the goods in existence, but the goods are already destroyed. It is called as what mistake now? Bilateral mistake about the existence of the goods. The agreement is void. What is void? Agreement is void. Mistake as to identity of the subject matter means I made an offer to sell X goods. You thought you are purchasing Y goods. That is called as what? Mistake about the identity of the goods. Agreement is void. Mistake about the what? Quantity of the subject matter or quality of the subject matter. All these cases, agreement is what? Void. Agreement is what? Void. Unilateral mistake. It can be about the nature of contract or identity of the person. If it is about nature of contract, what of contract? Nature of contract. Agreement is valid or void? Mistake, unilateral mistake about nature of contract. Agreement is what? Void. Identity of the person? Void. Generally valid. Unilateral mistake? Valid. But it's about, if it is about nature of contract or it's about identity of the person, the agreement is what? Void. Agreement is what? Void. Next, we have lawful object. What object? The object of the agreement must be what? Lawful. If it is unlawful, agreement is valid or void? Void. Enforceable, not enforceable? Not enforceable. When the object of an agreement is considered to be unlawful, what is the first situation? If it is forbidden by law. What is forbidden by law? Object is forbidden by law. If the object is forbidden by law, it is considered as what object? Unlawful object. For example, child marriage. What marriage? Lawful or unlawful? Unlawful. Not enforceable by law. It is of such nature, if it is permitted, to defeat the what? Purpose of the law. What of the law? Purpose of the law. You know what is purpose of the law, right? Object of the law. What of the law? If the object is permitted to defeat the purpose of the law. Remember, I have discussed the example where a person was trying to do something indirectly, which he can't do directly because he could not take part in the auction directly. He sent his friend to take part in the auction and to transfer it back to him. The contract between him and the friend, is it enforceable? Not enforceable? Not enforceable. Because if you allow that agreement, it defeats the purpose of the law. What of the law? Purpose of the law. Or if it is fraudulent, if the purpose of the agreement is to do what? Fraud. Enforceable, not enforceable? Not enforceable because the object is what? Unlawful. Object is unlawful. Next one. It involves or implies injury to the person or property of another. So if an agreement implies or involves an injury to the property or property of another person, that agreement is considered as what? Void because it is opposed to what policy? Public policy. What policy? For example, infringement of trademark, infringement of copyrights of some other person. Correct, right? Next one, court regarded as what? Immoral. If the court considers an object as immoral or opposed to public policy, it is considered as what object? Unlawful object. For example, this agreement in restraint of trade, parental rights, marriage brokerage agreements, all these are considered as opposed to what policy? What policy? Public policy. Valid or void? What is it? Valid or void? Void. Next one, void agreements and illegal agreements. Below, are void agreements enforceable by law? Not enforceable by law. Not enforceable by law. They are void from the beginning itself, starting itself. What is the case in case of illegal agreement? In case of illegal agreements, they are punishable by law. And one more major difference between void agreement and illegal agreement is that in case of illegal agreements, they are in case of illegal agreement, even the collateral agreements, what agreement? Collateral agreements are tainted with what? Illegality. Tainted with what? Hence not enforceable by law. Not enforceable by what? Laws. Next one, agreement void as opposed to what policy? Public policy. What policy? Public policy. Following agreements are void because they are opposed to what policy? Public policy. Against the public policy. What are the agreement which are opposed to public policy? Agreement in restraint of what rights? Parental rights. What rights? Parental rights. Correct, right? Means if a father and mother have an agreement where they have agreed that only mother can have an access to the child, is that agreement valid or not valid? Not valid. Why? Because both of them have a parental right. Next one, agreement in restraint of marriage. Restraint of what? Any person and every person has a right to get married once they become major. If by an agreement, one person restricts the other person right to get married, is that agreement valid or void? Opposed to what policy? Public policy. It can be an absolute restriction or it can be a partial restriction. But however, an agreement with a minor, agreement with whom? It is valid because anyway, minor cannot get married till the age of what? Majority. Age of what? Next one, marriage brokerage agreement. What is marriage brokerage agreement? An agreement to negotiate a marriage for a consideration. Marriage for what? Valid or void? Void. Not enforceable by law as it is opposed to what policy? Public policy. What policy? Public policy. Next one, agreement in restraint of what? Personal freedom. What freedom? Are valid or void? Void. Enforceable, not enforceable. For example, I make a promise that I'll not go anywhere. I'll stay only in Bangalore. Is this agreement valid or void? Void. Because I have a freedom to go anywhere I want. I have a liberty, personal liberty. Yes or no? Next one, agreement in restraint of trade. If one person restrict the other person from carrying a lawful business or trade, is the agreement valid or void? Void. Enforceable, not enforceable? Not enforceable. But however, there are exceptional cases if there is a partial restriction. What restriction? Are they valid or not valid? Valid. For example, sale of goodwill. Sale of what? Goodwill. In case of sale of goodwill, who can restrict whom? Buyer can restrict the seller from carrying what business? Similar business. What business? Within the particular locality for a reasonable period of time. What period of time? Reasonable period of time. Right, right. Next one, partner agreement. What agreements? In case of partnership agreement, who can restrict who? Where partners by an agreement can restrict that no partner shall carry the business outside the partnership firm when they are partners. Is that condition valid or not valid? Valid. Next one, trade combinations to regulate the trade. Any combinations are made to regulate the price. Is it valid or not valid? Valid if it is not anti-competitive. If it is anti-competitive, the agreement is void. Next one, negative stipulation. What stipulation? Negative stipulation. In what agreement? Service agreement. If there is an employer and employee contract, if employer by a contract restrict whom? Employee. Restricts who? Who restricts who? Employer restricts the employee. From what? From being employed anywhere else when he is employed with the employer. Is that condition valid or not valid? Valid. When you are in full-time employment, you cannot work anywhere else, right? Is that restriction valid or not valid? Valid. That is called as what? One more exception. One more what? Clear with this? These are the cases where agreement in restraint of business or trade is valid. Business or trade is what? Valid. Next one, wagering agreement or wagering agreement. Are they valid or void? Void. Wager means bet. The betting. Gambling agreements are valid or void? Wagering agreements are nothing but ordinary betting agreements. They are void except in Mumbai. Mumbai, they are what? Illegal. And they're also punishable by law. What by law? Punishable by law. Which agreements are punishable by law? Wagering agreement. In the what? State of Maharashtra. That is Mumbai. Mumbai is the capital city of what? Maharashtra. Pune is also in Maharashtra, na? Pune and Mumbai. And there are two ROC in Maharashtra. One in Pune and one in Maharashtra. Mumbai. Jai Maharashtra. Next one. Wide agreements. What agreements? Wide agreements. Are agreements. What are wide agreements? Agreements which are not enforceable by law are called as what agreements? Wide agreements. Agreement with minor. Enforceable, not enforceable. Agreement under mutual mistake of fact, not enforceable. Agreement without consideration, wider, valid or wider, wide. Agreement without consideration, agreement where the object is unlawful, void, not enforceable by law. Agreement in restraint of marriage, agreement in restraint of what? Marriage. Enforceable, not enforceable, not enforceable. Restraint of trade, void. Restraint of legal proceedings, I restrain you from filing a suit or enforcing your legal right. Any absolute restrictions on the enforcement of a legal right are curtailing the usual period for starting the legal proceedings. Tell me, what is the time limit to file a case as per Limitation Act? 3 years, but parties have valid only 2 years. Is that condition valid or not valid? Is that condition valid or not valid? Not valid. Why? Because any agreement by which a person is restrained from enforcing his legal right Absolutely or partial? Absolutely. Valid or not valid? Not valid. But arbitration, if there is an arbitration clause, is it valid? Yes, valid. If there is an arbitration clause, if the parties have agreed that if there is a dispute, it should be referred to arbitration. They're not restraining absolutely. They're restraining what? Partially. Is it valid? Yes, it is valid. Next one. If the meaning is uncertain. What is uncertain? Meaning is uncertain. If a meaning of an agreement is uncertain, is the agreement is valid or void? Void. Enforceable, not enforceable? Not enforceable. Correct, right? Example, if I make an agreement to sell oil, what type of oil? Agreement is void. Next one, wagering agreement. Are they valid or void? Void. Enforceable, not enforceable? Not enforceable. Agreement which is contingent upon the impossible event. What event? If I make a promise to pay 1 lakh rupees, if I discover treasure by magic, or if I say I will pay 1 lakh rupees, if you can enclose a space by drawing two straight parallel lines. What agreement? Void agreement. Agreement to do what activities? Impossible activities. What activities? All these are void. When a contract becomes void, when it is not enforceable by law. A contract ceases to be enforceable by law, becomes void when it ceases to be enforceable. Next one, because of what illegality? Subsequent illegality. What illegality? Subsequent illegality. A contingent contract. What contract? To do or not to do anything. If an uncertain future event happens, becomes void. If the event becomes what? Impossible. What becomes impossible? Event becomes impossible. Next one, where a contract is voidable at the option of which party? Aggrieved party. And if he cancels it, it becomes what? Void. Becomes what? Next, what is restitution? What is restitution? What is restitution? Means restore back. When a contract becomes void, it is not performed by what party? Either party. Or if any party has received any benefit under the such contract from the other party, he must restore it and make what? Compensation for it to which party? To the party. Correct, right? So whenever a party has received any benefit under a contract, the benefit received by him must be restored back to which party? Other party. No restitution where the parties are wholly incompetent to contract. Means if the agreement is void ab initio, there is no question of what? Restitution. The restitution is applicable only when the contract becomes void subsequently. For example, I made a promise to paint a picture. You have paid me the 1 lakh rupees, but I lost. I'm dead now. I'm no more. Now, in this situation, my legal heads must refund how much? 1 lakh rupees to you because this contract has become void subsequently. Right? So, right. Next one, no restitution where the parties are wholly incompetent to contract. That is, if they are minor. If there is what? Minor or unsound mind, there is no question of what? Restitution of property. What is restitution? Restoration. Tell me, an adjudication of the court for restitution of property, is it called as decree or order? Restitution of property, it's called as what? Decree. Restitution of property, decree. Rejection of plaint, decree. Dismissal of suit, order. Correct, right? Yes or no? Next one, quasi contract. What contract? Quasi contract. See, quasi contracts are not the real contracts. They're not made by the parties, but the obligations are imposed by the law to serve the justice. Serve the what? Justice. Where the rights and obligation between the parties is imposed and enforced by the law. It is called as what contract? Quasi contract. What contract? What contract? Quasi contract. It is based on the equitable principle. What principle? Equitable principle. It is an obligation which who creates? Law creates. Who creates? Law creates. Types of quasi contract. What is the first one? Liability for the necessaries. Liability for what? Necessaries. If you supply necessary items to a minor or a person who is incapable of contracting or the person whom they are bound to support, their asset is liable. What is liable? Asset is liable to pay for it. If I supply a food to the wife of the unsound mind person. Is the unsound mind person responsible? No. His asset is liable to pay for it. Under which contract? Quasi contract. Which contract? Next one, recovery of money paid by what? Mistake or by coercion or by what? Coercion. Any money paid by mistake or coercion can be recovered. Can be what? Under which contract? Quasi contract. What contract? Quasi contract. Next one, payment to third party of money which another party is what? Bound to pay. You are liable to pay property tax, but I paid it as a tenant. Can I recover it from the owner? That is called as what contract? Quasi contract. Next one, money obtained by defendant from which parties? Third parties. If I receive any money from third parties which belongs to you, am I supposed to give it back to you? Yes. Next one, quantum merit. What merit? What is quantum merit? As much as earned or as much as merited. If a person has done part of the contract, what of the contract? But fails to perform the full contract because of the fault of the other party. What party? Other party. The extent of work done. What done? To the extent of what done? Work done. Who can recover the compensation? The one who has done the work can recover the compensation. That is called as what? Quantum merit. What merit? Quantum merit. Clear? Next one, obligation of what of goods? Finder of lost goods. Finder of what goods? Can you keep it or supposed to restore it back? Who should restore it back? To whom? The owner. Next one, obligation of a person enjoying the what? Benefit of a non-gratuitous act. If one person does something, but he doesn't have an intention of doing it free of cost, can he recover it from the other person? Yes, we have discussed this in the section number 70. Non-gratuitous act. Is the government liable to pay? Not liable to pay? Liable to pay. Are you liable to pay? Not liable to pay? Liable to pay. Now see, we have spent, this is the third day of marathon, right? Full day, every day we have spent how much? 11 hours of time in the class. How many hours of time in the class? 11 hours. If I ask any random question now, believe me, you'll be in a position to answer out of how many chapters? 14 chapters. How many chapters? 14 chapters. Let me ask question now. Listen. What is the limitation? Is there any limitation period for enforcing a right available in case of trust? There is no what period? Limitation period. There is no what period? Limitation period. There is no what period? Limitation period. Right, right? Okay. One more question. Who classified the interest into three categories? Let's go. Wow. Which article provides right to equality? Right, sir? Article 14. Fundamental rights are justiciable, non-justiciable. What is reversionary interest? Equity reverts to the grantor. When the grantor has granted a limited interest after the expiry of which the property reverts to whom? Owner. That is called as what? Reversionary interest. Uh, Tell me if a person has obtained a if a person has obtained substituted performance, can he claim specific performance in case of tort? What is the essential requirement of a tort? Injurious in a damnum or damnum in a injuria? Is nervous shock is a tort? Nervous shock is a tort. Can a person who does not have a proximate relationship with the victim claim compensation for a nervous shock? No. There has to be a proximate relationship. Correct, right? Tell me, what is the place of filing a suit if the property is situated in the jurisdiction of two different courts? Any of the code. Correct, right? What is the punishment or maximum number of years of imprisonment which session court can pass? Session judge. What is the maximum imprisonment session judge can pass? Any sentence except sentence of death. It requires confirmation of the High Court. Session judge, additional session judge. 7 years is for arrest. Correct, right? Tell me if there is any execution of instrument, Darshan, execution of instrument in favor of a government. Is the stamp duty payable or not payable? Developer of SEZs, stamp duty is not payable. Adhesive stamps means what? Convenient labels affixed on the instruments. Correct, right? Yes or no? Is registration of gift of immovable property required or not required? Required. Mandatory or optional? Mandatory. Yes or no? Can a person be punished twice for the same offense? Why? Under which article? Double jeopardy, double jeopardy. See, I'm shifting from one chapter to another chapter, one concept to another concept, but still we are able to answer. ಇಷ್ಟು ಸಾಕಾಗಲ್ಲ ಇಷ್ಟು support like you need to do extra preparations from your side, solve the question bank questions that will help you guys to a greater extent. Okay, done. Okay, let's come back to the discharge of contract. What of contract? Discharge of contract. What is discharge of contract? End of contractual obligation between the parties to a contract. It is called as what? Discharge of contract. What do you mean by discharge? Discharge can be by what? Performance of contract. What of contract? Performance of contract. When both the parties perform their contractual obligation. What obligation? Contractual obligation. What comes to an end? Contract comes to an end. Correct, right? Both the parties fulfill their respective obligation, contract comes to an end. Next one, obligation of parties. Section number 37 provides that it is the obligation of the parties either to perform or offers to perform the respective obligation unless excused by the law. If there is a contract, you need to perform your obligation. Perform your what? Obligation. If you don't perform your obligation, are you liable or not liable? Liable. Liable or not liable? Liable. Who should perform the contract? Both the parties should perform the contract. Next one. Tender of performance. What is tender of performance? Tender of performance means where one of the parties is ready and willing to perform his promise, but other person refuses to accept it. Refuses to what? Accept it. That is called as what of performance? Tender of performance. Bolo what of performance? Tender of performance. Tell me in case of tender of performance. What of performance? Tender of performance. Who is not responsible? The one who makes an offer to perform will not be responsible. Not be what? Responsible. Correct, right? Next one, part performance. Correct. Next one, effect of refusal of party to perform what? Wholly. Means if the promiser fails to perform or refuses to perform his promise in its entirety, in its what? In its what? Entirety. In that situation, is the promiser responsible? Not responsible? Not responsible. Below responsible or not responsible? Not responsible. Sorry, promisee is not responsible, but promiser is responsible. Concentrate, everybody. Listen. If the promiser fails to perform the promise in its entirety or refuses to perform the promise, the promisee may put an end to the what? Contract and sue whom? Promiser for recovery of the damages. Recovery of what? Damages. Next one. Devolution of what liabilities? Joint liabilities. What are joint liabilities? If there are more than one promiser, more than how many promiser? To perform the promise, all the promisers during their joint lives. In case of death of any one of the promisers, the legal representative of the deceased promiser, along with what? Other promisers must perform the promise. Next one, release of one of the joint promiser. What do you mean by release of one of the joint promiser? Let's say X, Y, Z are there. They are the joint promiser to whom? To Mr. A. A releases only Mr. X. Does it mean Y and Z also released? No. Y and Z continues to be what? Liable. And X is liable to whom? Y and Z. Pay his contribution or his share of contribution. All these things we have discussed in detail in the case. Correct, right? Next, discharge by what? Mutual agreement. What agreement? Till now, whatever we discuss is by performance, by fulfilling the obligation. What comes to an end? Contract comes to an end. Next, we have my mutual agreement. What agreement? By mutual agreement or a consent, the contract comes to an end in the following scenarios. What is the first one? Novation. What is novation? Substitution of New contract. For which contract? Old contract. Which contract comes to an end? Old contract comes to an end. I have given many examples for this in the class. Correct, right? So when we substitute a new contract for the old contract, it is called as what? Novation. Called as what? Novation. What is alteration? Change in the terms of the contract. Change in the what? Terms of the contract. In case of alteration, contract comes to an end. What comes to an end? Contract comes to an end. Next one is what? Rescission of contract. What do you mean by rescission? What is rescission? Cancellation of the contract. In case of cancellation, also contract comes to an end. Correct, right? Both the parties by mutual agreement. What agreement? Can cancel the what? Contract. In that situation, what comes to an end? Contract comes to an end. Next one, remission. What is remission? Accepting lesser than what is due or giving more time to make the payment, or if a person if a person compromise with the rights available, it is called as what? Remission. In case of remission, also what comes to an end? Contract comes to an end. Last one is what? Waiver. What is waiver? Give up the rights. Give up the what? Rights. If a person has a right to file a case, but he gives up that right and he releases the person from his obligation, in all these cases, is the contract required to be performed? Not required to be performed. Not required to be performed. Next one is by what? Discharge by lapse of time. Lapse of what? It is also barred by which act? Limitation Act. If it is barred by Limitation Act, obligation comes to an end. Next one, by operation of law. In the following cases, law itself provides that parties are not required to perform their obligation. What is the first one? Merger. What is merger? Just now we discussed in case of Transfer of Property Act also. Mortgage. See, you have taken the property on rent basis for 1 year, but within 3 months you purchase the property by yourself. And what comes to an end? Rental agreement comes to an end by merger. A contract giving an inferior right gets merged with the contract giving what right? Superior right. Which contract comes to an end? When a contract giving the inferior rights gets merged with the contract giving the superior right, which contract comes to an end? Contract giving the inferior rights comes to an end. Next one, by unauthorized alteration. What alteration? Unauthorized alteration in the what? Items of the return contract. What contract? Return contract. If there is any alteration in the terms of the contract by the parties without the consent of other parties, what comes to an end? Contract comes to an end. What comes to an end? Contract comes to an end. Next one is by what? Insolvency. Next one is by what? If one of the party becomes an insolvent, what comes to an end? Contract comes to an end. Next one, discharge by impossibility or frustration. Impossibility or what? Impossibility means what? If the promise is impossible to perform, it can be of how many types? Two types. Initial impossibility, supervening impossibility. Both the cases, agreement is what? Void. Enforceable, not enforceable? Not enforceable. I made a promise to sell a dog which is dead. Possible to perform, impossible to perform, impossible to perform. I made a promise to run 1,000 kilometers per hour. Possible to perform, impossible to perform. I made a promise to take class for 20 hours a day. Possible or not possible? Possible or impossible? Impossible. Already we have clocked already 11 hours, extra 9 hours. Do you think it is impossible? Possible. Yes, it's possible. Where there is a will, there is a way. Exactly. Where there is CSR, there is a way. Next one. Next one, what impossibility? Initial impossibility. What impossibility? See, if the impossibility persists at the time of entering into a contract itself, it is called as what? Initial impossibility. Agreement is valid or void? Void. What is subsequent impossibility? If the impossibility arises after the contract is made, after what is made, contract is made. It is called as what impossibility? Subsequent impossibility. Agreement is valid or void? Void. Agreement is valid or void? Void. Death of a person, declaration of war. Now there is a war-like situation between India and Pakistan. Now contract made during this period, or contract made before the war, are all suspended now. That becomes what? Void. Enforceable, not enforceable? Not enforceable. Or but however, increase in the price, change in the condition, strikes in the factory, lockout of the factory, these are not called as what? Impossibility, and the promisor is bound to perform. And if he fails to perform, is he liable to pay compensation? Not liable to pay compensation, liable to pay the compensation. Are you guys clear with this? Next one, discharge by breach of contract. What of contract? अरे बोलो what of contract? Breach of contract. Breach of contract can be of how many types? Two types. What are the two types? Actual breach of contract, anticipatory breach of contract. What is actual breach of contract? Before when the promiser refuses to perform on the date when the which on which the promise is due for performance. It is called as what? Actual breach of contract. What is anticipatory breach of contract? If what is anticipatory? Before the due date. Before what date? Due date. It is called as what breach of contract? Anticipatory breach of contract. What breach of contract? Yes or no? Remedy for the breach of contract. See, there are how many types of breach of contract? Two types. Actual breach, anticipatory breach. If the promiser If the promiser refuses to perform the promise before the due date, it is called as what? Anticipatory breach of contract. On the due date, actual breach of contract. And I have discussed what are the consequences of anticipatory breach of contract. If a promiser refuses to perform the promise before the due date, who can cancel the contract? Promisee can resign the contract. Who can resign the contract? Promisee can resign the contract. Remedy for the breach of contract. What are the remedies for the breach of contract? What is the first one? Suit for damages. It can be of how many types? Two types. Liquidated damages and unliquidated damages. What is liquidated damages? Which are agreed by the parties in the contract itself. They are called as what damages? Liquidated damages. What are unliquidated damages? Not agreed by the what? Parties. And who will decide this? Court will decide this. What are ordinary damages? If the court awards, who award? Court award the actual loss arising out of the contract, the natural loss, the loss which naturally arises out of the breach of contract. It is called as what damages? Ordinary damages. If a court gives a compensation for the loss which is naturally arising out of the breach of contract, it is called as what? Ordinary damages. Nothing but difference between market price and contract price. It is called as what? Ordinary damages. What damages? Ordinary damages. Next one is what damages? Special damages. What damages? Special damages are the damages which are awarded by the court for incidental losses. What losses? Special damages are awarded by the court only if the special circumstances are known to whom? Both the parties. What parties? At the time of entering into a contract. If the special circumstances were in the knowledge of the parties at the time of entering into a contract itself, in that situation, the court may award the compensation for incidental losses. What losses? Next one, what is exemplary damages to punish a person? So when a court gives some amount of money as a compensation to punish a person, it is called as what? Exemplary damages. So exemplary damages are given for a promise to for a breach of promise to marry a girl or a boy or a wrongful dishonor of check. What object? Wrongful dishonor of check. Next one is nominal damages. What damages? Namesake damages when there is no loss suffered, but just to record the fact of breach of contract. If the court gives some amount of money as a compensation, it is called as what? Nominal damages. What is specific performance? Am I supposed to explain specific performance? We already discussed now a remedy in specie. When a court compels the person to fulfill the promise he has made in a contract, it is called as what? Specific performance. What performance? Injunction, equitable remedy to prevent a person from doing something or to compel a person to do what? Something. It is called as what? Injunction. So with these, we are done with what? General principles of contract. What principles of contract? General principles of contract in 1 hour 15 minutes. General principles of contract. What principles of contract? General principles of contract, which it takes 60 hours to complete in normal cases. Okay? Yes or no? What principles of contract? General principles of contract. Now you guys tell me, offer plus acceptance is what? Promise. Promise plus consideration is what? Agreement. Agreement plus enforceable by law is what? Contract. Yes or no? Next, we have special contracts. What contracts? Section number 124 to 238 deals with special contracts. What contracts? Special contracts. What is the definition of? We have five special contract: indemnity, guarantee, bailment, pledge, agency. What are they? Indemnity, guarantee, bailment, pledge, and agency. What is the first one? Indemnity. What is the first one? Indemnity. What do you mean by indemnity? Listen, everybody. What is indemnity? It's a contract by which one person promises to save whom? Other person from the loss caused by the what? Conduct of the promiser himself or by any other person. What person? Any other person. That is called as what bond? Indemnity bond. What bond? Have you heard about indemnity? See, simple say simple. I make a promise. I make a promise to the company. That company issue a duplicate certificate. For issuing duplicate share certificate, if you incur any losses, who will compensate you? I will compensate you. That is called as what? Contract of indemnity. Contract of what? Indemnity. In an indemnity, there will be how many parties? There will be how many parties? Two parties. What are the two parties? Indemnifier, indemnity holder. What are they? Indemnifier and indemnity holder. The one who makes the promise is called as what? Indemnifier. And who is indemnity holder? The person to whom what is made? Promise is made is called as what? Indemnity holder. I repeat, what is indemnity contract? It's a contract by which one person promises to save whom? Other person from the what? Loss. The loss can be caused by whom? Promiser himself or by any other person. There will be how many parties in indemnity? How many parties? Two parties. Who are they? Indemnifier, indemnity holder. So now, what are the rights available to indemnity holder against whom? Indemnifier. Let's say I made a promise that if X filed a case against you, and if you suffer any loss, who will compensate you? I will compensate you. Right? I made a promise to compensate you for any losses caused to you by the conduct of which party? Third party. Which party? If he file a case against you and if you suffer the loss, I will save you from the loss. Now called as what? Indemnifier. You are called as what? Indemnity holder. If the other person file a case against you and court order you to pay some amount of compensation, what of compensation? Amount of compensation. Now who will pay that compensation? Indemnifier will pay the compensation. And if you incur any cost to defend the suit, who will pay that cost? Indemnifier. Or if you enter into a compromise and agree to pay some amount of money, who will pay that some amount of money? Indemnifier. Who will pay the some amount of money? Indemnifier. Are you guys clear with this? Rights of what holder? Indemnity holder. What holder? He can recover what? All damages, cost, as well as the sum. As well as the what? Sum. Clear with this? Contract of what? Contract of what? Indemnity. What is contract of indemnity? It's a contract in which one person promises to save whom? Other person from the loss caused by the conduct of the promiser himself or by any other person. How many parties? Two parties. Indemnifier and indemnity holder. Next one, guarantee. What is guarantee? It's a contract to perform or fulfill the promise of which party? Third party. It's a contract to perform the promise or discharge the liability of a third party in case of his default. There will be three parties: surety, creditor, debtor. Who makes a promise here? Surety. To whom? Creditor. Perform whose promise? Debtor's promise. When who defaults? Debtor default. That is called as what? Contract of guarantee. Contract of what? There will be how many parties? What are the three parties? Surety, creditor, debtor. Who makes a promise to whom? Surety. To whom? To perform whose promise? In case of whose defaults? Debtors defaults. Whose default? Debtors default. That is called as what? Contract of guarantee. And in case of guarantee, there should be consideration for whom? Surety. What is the consideration for surety? Anything done. What is that? Anything done or promise made for the benefit of debtor. Benefit of whom? By creditor is the consideration for whom? Surety. So there must be a consideration because past consideration is not valid in case of what? Guarantee. In case of what? So the creditor should do something as per whose desire? Surety's desire. Whose desire? That is, he should supply goods or should give time to the debtor. That's right. That is called as what? A valid consideration for surety. See, I'm not receiving any benefit, but you are doing something as per my desire, right? You are supplying goods to debtor or you are giving time to him. to make the payment. All these are considered as what? Consideration for the surety. What for the surety? Consideration for the surety. Are you guys clear with this? Tell me, a guarantee without consideration, valid or not valid? Not valid. Valid or not valid? Not valid. Next one, nature and extent of what liability? Surety is liability. What liability? Surety is liability. The liability of the surety is co-extensive. What extensive? With that what debtor? Principal debtor. What debtor? Unless it is otherwise provided by the what? Contract. Provided by the what? Contract. Yes or no? The liability of the surety is co-extensive. What extensive? If the debtor is liable, who is also liable? Surety is also liable. To what extent he is liable? To whatever the extent who is liable, debtor is liable. Then who is liable? Surety is liable. If debtor is liable for 1 lakh, surety is liable for how much? 1 lakh. If debtor is liable for 2 lakh, surety is liable for how much? 2 lakh. But however, the surety may restrict the liability by having an express provision. What provision? If he has clearly agreed that he is liable only for 1 lakh, what extent is liable? 1 lakh. If not agreed, his liability is co-extensive. What extensive? With that of what debtor? Principal debtor. What debtor? Principal debtor. Next one. The creditor has a right to sue the surety directly without filing a case against whom? Principal debtor. What debtor? Creditor has a right to sue whom? Surety directly without first filing a case against whom? Principal debtor. What debtor? Principal debtor. There are how many types of guarantee? Two types of guarantee. Below, how many types of guarantee? What are the two types of guarantee? Specific guarantee and continuing guarantee. What is specific guarantee? If a guarantee is given for a single transaction, what transaction? Or a single that it is called as what guarantee? Specific guarantee. If a guarantee is given for series of transaction, what of transaction? Series of transaction. That is called as what guarantee? Continuing guarantee. What guarantee? Is single transaction, specific guarantee. Series of transaction, continuing guarantee. Next one, revocation of continuing guarantee. What is revocation? Cancellation. What is revocation? A continuing guarantee can be revoked by giving a what? Notice having effect on what transaction? Future transaction. What transaction? For whatever happened already, surety liable or not liable? Liable. But whatever has not yet happened, or for the transactions which are yet to happen in the future, can surety cancel it? Yes, by giving what? Notice. By giving what? Notice. Clear with this? So a continuing guarantee. What guarantee? Continuing guarantee can be revoked by giving a what? Notice. Having effect on what transaction? Future transaction. In case of death of surety. Death of what? Operate as what? Revocation of continuing guarantee. Having effect on what transaction? Future transaction. What transaction? Whatever happened is liable or not liable? Liable. Clear with this? Matlab is legal heads are responsible to the extent of assets they inherit. Next one, discharge of surety. What of surety? What is discharge of surety? What is discharge of surety? End of surety's obligation. When or how the surety's obligation comes to an end. What is the first one? Notice of revocation. Notice of what? Important. Based on this, they may ask question in the examination. In what cases the surety's obligations are discharged? What is the first one? Notice of revocation. Notice of what? Who can revoke it? Surety. By giving notice to whom? Debtor. Notice to whom? Next one, death of what? Surety. Continuing guarantee. Surety dies. Surety comes to an end. Next one, variation in the terms of the contract. If the debtor and creditor changes the terms of the contract without whose consent? Surety's consent. Surety comes to an end. Next one, release of whom? Principal debtor. What debtor? If the principal debtor is released from the obligation by the creditor, then who is also released? Surety is also released. Next one, creditor arrangement or compromise with whom? Debtor. If the creditor enters into a compromise or arrangement with the debtor without whose consent? Surety is consent. Who is discharged? Surety is discharged. Next one, by act of creditor against what? Rights of surety. Rights of what? If the creditor destroy the eventual remedy of the surety, eventual remedy of what? Surety. Who is discharged? Surety is discharged. For example, debtor has given gold jewelry as a security for the repayment of debt. So if the debtor defaults, who will make the payment? Surety makes the payment. Once surety makes the payment, he is the one who is having a right to receive the what? Gold jewelry. Correct, right. But what if the creditor has lost it? Now who is discharged? Surety is discharged. Last one, creditor part away with any security, that is assets. If he sells them or if he lost them, if you lose them, then who is discharged? Surety is discharged. Who is discharged? Surety is discharged. Correct, right? Yes or no? Next one, next one. Rights of surety. What of surety? Rights of surety. The surety is rights against the what? Creditor. Rights against the what? Surety has a right to receive all the assets which are given by whom? Debtor. To whom? Creditor. To whom? Creditors. Correct, right? Who can recover? Surety. From whom? Creditor. Next one, rights against principal debtor. What debtor? What debtor? He, once the payment is done, surety stands in the shoes of whom? Creditor. Whatever the rights creditor had against whom? Debtor. Who gets those rights? Surety gets those rights, including the right to recover the money and also right to be indemnified. Right to be what? Indemnified. Last one, sureties right against the co-sureties. What sureties? Who are co-sureties? More than one sureties are there. He can compel the other co-sureties to contribute equally. Contribute what? Equally. Correct, right? Three persons have made a promise to be a surety for 3 lakh rupees. If one person spend entire 3 lakh rupees, he can recover 1 lakh rupees each from whom? Other co-sureties. What sureties? Other co-sureties. Yes or no? Clear with this? Understood? समझ में आ गया? Next we have bailment. Next we have what? Bailment. Bailment. What is bailment? Delivery of goods by one person to another person upon a contract or a condition that the goods should be returned or disposed once the purpose is accomplished. What is accomplished? Purpose is accomplished. That is called as what? Bailment. Called as what? So in case of bailment, there will be what? Delivery of goods. What of goods? Delivery of goods by whom? One person to another person. For what purpose? Some purpose. The purpose can be to what? Carry the goods, to keep the goods, to do some work on the goods. Correct, right? That is called as what? Bailment. Called as what? Bailment. What is bailment? Delivery of goods. What of goods? Delivery of goods by one person to, upon a contract that the goods must be returned or disposed in accordance with whose instruction? Bailer's instruction. There are how many parties in a bailment? Two parties. Who are the two parties? Bailer and bailee. The one who delivers the goods is called as what? Bailer. Other person is called as what? Bailee. Called as what? Bailee. Duties of bailee. Duties of whom? What are the duties of bailee? Who should take the reasonable care? Bailee should take the reasonable care of whom? Whose goods? Bailiff's goods. What goods? Bailiff's goods. If a bailee has taken the reasonable care of an ordinary man with ordinary prudence, what prudence? Ordinary prudence. If something happens to the goods, who is not responsible? Bailee is not responsible. Who is not responsible? Then who is responsible? Bailiff. If he has not taken the reasonable care, if something happens to the goods, then who is responsible? Bailey only responsible. Next one, not to make what use of goods? Unauthorized use of goods. What use of goods? Under the first duty of the Bailey? What is the first duty of the Bailey? What care? Reasonable care. Second one, not to use in what manner? Unauthorized manner. You should not make an unauthorized use of the goods paid. Right, right. If it is authorized to use for a particular purpose, you should use it in what manner? In the same manner. Next one, he must keep the goods bailed separate from what goods? His own goods. What goods? What goods? Own goods. You should not use the goods. You should not what? Use the goods in a what manner? Unauthorized manner, and he should not mix the goods of the bailiff with whose goods? His own goods. Correct, right? If he mixes the goods, then who is responsible? To whom? Bailiff. Correct, right? There can be three. He must keep the goods bailed to him separate from the what? Own goods. What goods? There are three consequences: with consent mixture, without consent mixture, without consent mixture, and goods cannot be separated. What is the first one? What is with consent mixture? If the goods are mixed with the consent of bailer, then both the parties, if the goods are mixed with the consent of whom? Bailer, then both the parties will have the share in the mixture produced proportionate basis. What basis? Proportionate basis. Right, right. Second one, without consent mixture. What mixture? What is without consent mixture? If the goods are mixed without the consent of whom? Without the consent of whom? Bailer. In that situation, what happens? If it is possible to separate them, possible to what? Separate them. Who should bear the cost of separation? Bailey should bear the cost of separation. And if there is any loss during the separation, who has to bear it? Bailey should bear it. He should compensate the bailer. Without consent mixture and the goods cannot be what? Separated. Then who would be responsible? Bailey to whom? Bailey to whom? Bailer. Correct, right? Without consent mixture, goods cannot be separated. Who is responsible? Bailey. To whom? Bailer. Correct, right? He should compensate the bailer. He must not set a what title? Adverse title. He should not try to make the goods of his own. Correct, right? Next one, return the goods. Who should return the goods? Bailey to whom? Bailer. Without any demand after the purpose is accomplished. What is accomplished? Purpose is accomplished. Return the accretion. What is accretion? Increase in the value of the goods or increase in the goods. Who should return it? Bailey. To whom? Bailer. Duties of bailer. Bailer should disclose the what? Fault in the goods. What in the goods? Who should disclose it? To whom? If it is a gratuitous bailment, he must disclose all the known faults. If it is not disclosed, bailey suffers the loss. Who is liable to compensate? Bailer is liable to compensate. If it is non-gratuitous bailment, then who is supposed to disclose all the faults? Bailer. Even if he was not aware about the fault, and because of the fault, if the bailey suffers the loss, who is liable to pay compensation? Bailer to bailey. Who should pay necessary expenses? Bailer. If the bailment is for the benefit of the bailer, and the bailey is to receive no remuneration for the work, then who has to pay all expenses? Bailer. To whom? Bailey. If it is for reward, bailey will bear the necessary expenses. Bailer should pay what expenses? Extraordinary expenses. But if it is not for a reward, it is for the bailer's benefit. Whose benefit? Then who has to bear all the expenses? Who has to bear all the expenses? Bailer or bailey? Bailer has to pay the all expenses. Who has to pay all expenses? Bailer. Bailer. Next one. Duty to what? Indemnify the bailey for the what title? Defective title. What title? What title? If a bailer has a defective title, because of that, if bailey suffers the loss, for example, if there is no PC certificate on the vehicle, or if there is no insurance, bailer has given the vehicle to bailey on a hire, and while driving, police caught him, and he was supposed to pay 10,000 rupees of fine. Now he can recover the same from whom? Bailer, because he suffered the loss because of whose defective title? Bailer's defective title. Next one, termination of bailment. What are bailment? What is termination? End of bailment. The bailment comes to an end in what cases? Following cases. What is the first one? Expiration of what time? Stipulated period. What period? Stipulated period. Next one. Fulfillment of what? Purpose. Fulfillment of what? What is the first one? Expiry of stipulated period. 3 months. 3 months gets over, bailment comes to an end. Next one, fulfillment of the purpose of bailment. Next one, by notice. If it is a gratuitous bailment, it is without consideration. Who can cancel it? Bailer can cancel it by giving notice to whom? Bailey. Next one, by death of the bailer or bailey. If it is a gratuitous bailment, the bailment comes to an end by death of whom? Either the bailer or bailey. Bailer or what? Next one, destruction of subject matter. What matter? Subject matter. What do you mean by destruction of subject matter? If the goods are destroyed. What is destroyed? What comes to an end? Bailment comes to an end. What comes to an end? Bailment comes to an end. Next one, finder of lost goods. Finder of what goods? Finder of lost goods is considered as what? Bailey. I think I've discussed this concepts elsewhere. Have I discussed this concept? The finder of lost goods is considered as what? Bailey. He must return the goods back to whom? Bailor. Must return the goods back to whom? Bailor. And does he has a right to sue the owner for compensation for the trouble and expenses he incurs voluntarily? No. He can't file a case, but he can retain the goods. Who can retain the goods? Bailey can retain the goods. Sir, who can retain the goods? He can retain the goods until he receives the what? Compensation. Receives the what? Compensation. If there is a specific reward, what reward? For the return of the goods lost, he may retain the goods until he what? Receives it. Until he what? If there is a reward, he can file a suit. But he cannot file a suit for recovery of expenses he has incurred voluntarily. Correct, right? Can a person who finds the goods of other person sell it? If you find someone else's goods, can you sell it? But if it is a perishable goods and the lawful expenses incurred by you to protect the goods amounts to how much? Two-thirds of the value of the goods. If it exceeds how much? Two-thirds of the value of the goods. Can you sell it? Yes or no? Yes. Other than these two exceptional cases, can you sell? Can you sell? Uh, can you sell what? Goods you have found? No, you're not supposed to sell. Next one, carrier as a bailey. What as a bailey? Is carrier is considered as the bailey? Yes, they're liable to the one who consigns the goods as a bailey. As a what? Bailey. Or as a what? Bailey. Same rights of bailey is available even for a carrier. Even for a what? Carrier. And these are the provision with respect to what? Bailment. With respect to what? Bailment. Then we have pledge and agency. Pledge and what? Agency. So, bailment of pledges. What is a pledge? Pledge means a bailment of goods as a security for the repayment of loan or the performance of a promise. It is called as what? Pledge. In case of mortgage, it is for immovable property. Pledge is for what property? Movable property. That is a major difference between mortgage and pledge. Pledge means what? When there is a delivery of goods as a security for the payment of debt or performance of a promise. It is called as what? Bailment of pledges. What are pledges? Bailment of pledges. What are the parties to a bailment or a pledge? Two parties. What are the two parties? Honor and pawnee. Pledger and pledgee. The one who pledges the goods is called as the pledger, and the person to whom the goods are pledged is called as what? Pledgee. Rights of the pawnee. What are the pawnee? Rights of the pawnee. What are the rights of the pawnee? He has a right to retain the pledged goods until what? Loan is repaid. Loan as well as the interest is repaid. He has a right to retain the goods for what? For the repayment of debt as well as the interest due on the debt amount. Pawnee right where the pawner makes what? Defaults. Who makes the default? Pawner makes the default. If a pawner makes the default, who makes the default? A pawner makes the default. Who has a right? Pawnee has a right. What? Give a notice and sell it and to recover the money. Next one, pledge by non-owner. Pledge by whom? Generally, who can pledge it? Owners can pledge it. But there are exceptional cases where who can pledge it? Non-owner. The person who is not an owner can pledge it. That is called as what? Pledge by what? Non-owners. What owners? Example, mercantile agent. What agent? Any mercantile agent, that is business agent having the possession of the goods in the ordinary course of business pledges the goods to a person acting in what faith? Good faith. Means he was not aware about the fact that the agent did not have the right to pledge the goods. In that situation, is the pledge valid or not valid? Valid. Pledged by what agent? Mercantile agent. What agent? Mercantile agent. Next one, pledged by whom? Seller. Pledged by whom? Are the buyer in possession after sale. Possession after what? Sale. If a person pledges the goods after sale, who is the owner? Buyer is the owner. Who is the owner? But having possession, if a seller pledges them to a person acting in what faith? Good faith. Is the pledge valid? Yes. We have discussed sale by non-owners. What owners? Non-owners under the Sale of Goods Act. Which act? Same provision applicable even for the pledge by a non-owner. Next one, pledge where the pawner having what? Limited interest. What interest? If a pawner is having limited interest, can you pledge the goods? Yes. to the extent of his interest. For example, I have a right to the extent of 1 lakh rupees on a property worth of 2 lakh rupees. Tell me, can I pledge this to borrow a loan of 1 lakh rupees? Yes, because I have an interest to the extent of how much? 1 lakh. Even though I'm not the absolute owner, still I can pledge the goods to the extent of how much? 1 lakh. Next one, pledged by what owner? Co-owner. One of the co-owner having the possession of the goods can pledge the goods with the consent of which owner? Without the consent of which owner? Other co-owner, provided at the time of pledge he was having the possession of the goods, and the person to whom pledge is made acted in what faith? Good faith. What faith? Next one, pledged by a person in possession under which contract? Voidable contract. Person having possession of the goods under a voidable contract before the sale. Before the what? Before the contract is cancelled. What is cancelled? Contract is cancelled. For example, I repeat, I have taken your consent by force and I'm having the possession of the goods. And before you cancel the contract, before you cancel the what? Contract. Before you cancel the what? Contract. If I sell it to somebody or pledge it to somebody acting in what faith? Good faith. Is the pledge valid or not valid? Valid. These are the cases. These are the exceptional cases. What cases? Where pledged by a non-owner is valid. Is what? Valid. Are you guys clear with this? These are the provision with respect to what? Pledge. Respect to what? Bailment of pledges. Bailment of what? Pledges. Next we have agency. What do we have? Agent. Who is an agent? A person employed to do an act for another or to represent another in a dealing with which party? Third party. What party? He is called as what? Agent. Called as what? So agency can be expressed agent as well as what? Implied. Agency can be created either by what? Expressed contract. We also call it as power of attorney. There are two types of power of attorney. General power of attorney, special power of attorney. That is called as what? Expressed agency. What agency? Then we have implied agency, where the agency contracts are implied by the what? Conduct of the parties or by the circumstances or by the what? Example, we have a special agent. What agent? What agent? That is types of agent. In case of implied agency, we have agency by estoppel, where one person represents himself as an agent of other person, or if the principal allows someone to represent himself as a agent, then principal cannot deny his liability at a later stage. What stage? If she represent me as her principal and if she enters into a contract with a third party acting in what faith? Good faith. Will I be responsible or not responsible? Responsible. It is called as what? Agency by estoppel. Agency by estoppel. Next one. Wife as a what? Agent. Wife as a what? So now wife is considered as an agent for the purchase of what assets? Necessary item. What item? For purchasing the necessary item. Who is considered as agent of whom? Wife is considered as an agent of the husband. And for the act of wife, who is responsible? Husband is responsible. Wife can pledge the credit of the husband for purchase of what item? Necessary item. What item? Next one, agency by what? Necessity. What do you mean necessity? Emergency. What do you mean by necessity? Emergency. For example, a person is carrying tomatoes or vegetables and he is stuck in between the destination and the departure. And the only road connecting the destination is destroyed and he cannot reach for another 10-15 days. Correct, right? Now, if you don't sell them, what will happen? There will be loss to the principal. To avoid the loss to the principal, without authority, the carrier sold them. Now, is it considered as a valid sale? Yes. And it will be considered as what? Agent by necessity. Agent by what? Necessity. Next one, ratification. What is ratification? Approval. Alright, what is ratification? If an agent goes beyond his authority or act without authority, who can approve it? Principal. If he approves it, who becomes the agent? That person becomes the agent. And who will be responsible? Principal will be responsible. And we also discuss the requisites for a valid ratification. What ratification? Valid ratification. Principal must have the full knowledge of all material facts. Only lawful acts can be ratified. It cannot injure the rights of which parties? Third parties. Which parties? All these are the essentials of what? Valid ratification. What ratification? Next one, types of agent. What of agent? What are the types of agent? What is the first one? If a person is appointed to do a particular act, what act? Particular act or a single transaction, he is called as what agent? Special agent. What agent? We appoint special agent by what our power of attorney? Special power of attorney. What power of attorney? And we appoint a general agent by what? GPA to do multiple activities. Then he is called as what? General agent. What agent? Who is sub-agent? The agent appointed by and acting under the control of an agent. He is called as what agent? Sub-agent. What agent? An agent appointed by the agent is called as what agent? Sub-agent. Sub-agent is responsible to whom? Agent, not to the whom? Principal. Next one, mercantile agent. What agents? Nothing but business agent. Who are the mercantile agent? Who is the first one? Factor. He is the one who is having the possession of the goods and he sell the goods on behalf of whom? Principal. Next one, brokers. Who does something on behalf of whom? Principal. For example, share market brokers. Zerodha is a broker. They sell the shares or buy the shares on behalf of you. Next one, del creditor agent. What agent? He is an agent who receives the extra remuneration. What remuneration? For taking the risk of recovery of the money. Risk of recovery of what? Money. Then we have auctioneer. Who is auctioneer? The one who conduct the auction is called as what? Auctioneer. He sell the goods of the owner on behalf of him. Yes or no? Next one, partner. Next one is what? One partner is the agent of which partner? Other partner. Next we have bankers. Next we have what? Bankers perform the various activities on behalf of the customers. Correct, right? They collect the dividend or they collect the interest. They make the payment. In that situation, banker is considered as what? Agent. Of whom? Customers. Agent of whom? Next we have duties of agent. What of agent? Now, what is the first duty? He must act within the scope. Who must act within the scope? If he goes beyond the scope, then who is not responsible? Principal. Next one, he should follow the customs prevailing. If there are specific instruction, follow specific instruction. No specific instruction, follow what? Customs. Customs prevailing in the same business. What business? Same business. Next one, he must exercise what skill? Reasonable skill. What skill? And also what? Diligence while carrying out the activities of the principal or business of the principal. Next one, you should not disclose what information? Material information. What information? Who should not disclose material information? Agent. Next one, confidential information. What information? Who should not disclose the confidential information obtained? Agent during the principle of agency. Next one, conflict of his what? Duty. He should always work for whose benefit? Principal benefit. He should not put himself in a situation where there is a conflict of duty. Conflict of what? Duty. Next one, keep what accounts? True accounts. What accounts? True accounts. Who should keep the true accounts? Agents. Next one, must not make any secret profit. What profit? And they should not delegate the powers to whom? Any other person. That is why if an agent appoints a sub-agent, it is not valid. It is valid only if he was authorized or the customs warrants it or allows it. Clear? So generally, a delegatee cannot further delegate. Means an agent cannot appoint whom? Sub-agent. Cannot appoint whom? But if he is authorized by the principal, he can appoint the sub-agent. Appoint the what? Sub-agent. Are you guys clear with this? Yes or no? Rights of an agent. What of an agent? Rights of an agent. What is the first one? He can receive the what? Remuneration. Receive the what? Who can receive the remuneration? From who? Principal for the work done. But however, if he does the misconduct in his business, to the extent of misconduct, he cannot receive the what? Remuneration. Next one, he has a lien. Who has a lien? Agent. What do you mean by lien? Right to withhold the whatever he has, which belongs to the principal, unless until he receives his what? Remuneration. Next one, right to be indemnified. Right to be what? Who has the right to be indemnified? Who has a right to be indemnified? Agent. For the loss he suffers while carrying the activity or business of whom? Principal. From whom? Principal. From whom? Next one, responsibility of the principal to which parties? Third parties. Are which parties? Tell me, if an agent does something on behalf of principal, who is responsible to third parties? Principal. Because agent is just a it's a means through which contract is made. He's just an intermediary. The actual contract or the privity of contract happens between whom? Principal and third party. Principal and what? And for the act of third party, who is responsible? For the act of agent, who is responsible? Principal is responsible. To whom is responsible? Third parties. Correct, right? There are three situations. Disclosed principal. What principal? If the agent discloses the name of the principal, who is responsible? Principal. Second one, undisclosed principal means agent mentioned that he is acting as someone's agent, but he fails to disclose the name of who? Principal. Name of who? Without disclosing the name of the principal, he is entering into a contract with third party. Third party knows that he is someone's agent, but name is not disclosed. In that case also, who can require the performance of contract from third party? Principal. Correct, right? So the privity of contract happens between whom? Principal and third party. Even though what is not mentioned here, name is not mentioned. What if principal is concealed? Agent enter into a contract in his own name without even mentioning the fact that he is someone's agent, and the third party believes that he is entering into a contract with agent itself. Now who is responsible? Agent, not the principal. Neither principal can sue third party for performance of the contract, nor the third party can sue whom? Principal. Because the privity of contract happens between whom? Agent and third party. Agent and what? Third party. Next one, personal liability of what? Agent to third party. Agent to whom? Agent to whom? Agent to whom? Tell me, generally for the act of agent, who is responsible? Principal is responsible, but there are exceptional cases. What cases? Arey bolo, what cases? For the act of agent, who is responsible? Agent only responsible. What is the first situation? Where agent has agreed to be what? Personally liable. Important topics. Based on this, there can be a question in the examination. What is the first one? Agent has agreed to be liable personally. Liable what? Personally. Second one, agent act for the principal residing where? Residing where? Abroad. Because you cannot sue the person who is in abroad. Okay. You can make whom responsible? Agent responsible. Next one, he signs a negotiable instrument in his own name without making it clear that he is signing it only as a what? Agent. Next one, agent act for the what? Principal who cannot be sued. That is minor or unsolved. Then who is only responsible? Agent only responsible. Agent exceeds the what? Authority or for the tort committed by whom? Agent. Who is only responsible? Agent only responsible. Then we have something called as agency coupled with interest. What is coupled with interest? When the agent work for himself as well as for the benefit of whom? Principal. That is called as what? Agency coupled with interest. That cannot be terminated by whom? Principal. Principal cannot cancel which agency? Agency coupled with interest. What is coupled with interest? Agency coupled with interest. What do you mean by agency coupled with interest? Where the agent has a personal interest or personal right. He worked for the benefit of the principal as well as for his own benefit. For example, I am liable to pay Mr. X 1 lakh rupees and Mr. Y is liable to pay me 1 lakh rupees. Now I appoint Mr. X to recover money from whom? Y, and to keep it for himself. Now, Mr. X will act as an agent for whom? For me as well as for his own benefit. He recovers the money and he keep it for himself. That is called as what? Agency coupled with interest. Coupled with what? Interest. Termination of agency. What of agency? What do we mean by termination of agency? The cases or situations in which what comes to an end? Agency comes to an end. Below what comes to an end? What is the first situation? By performance. By what? Array bolo by what? Performance. Second one by agreement. By what? Third one, expiry of time. What is the first situation? By performance. Second one, performance means I have appointed you to perform particular activity. Once that performance is done, contract comes to an end. Second one, by agreement. By what? By agreement, they can discharge. Third one, expiry of time. What of time? I have appointed you as an agent for 3 years. Once the 3 years period get over, what comes to an end? Agency comes to an end. Next one. By what? Death of whom? Agent or the principal. Agency comes to an end. Next one. insanity, insolvency, or dissolution of company. Directors are the agents of the company. If company only dissolve, where is the question of directors acting as an agent? Next one, destruction of what matter? Subject matter. What matter? What comes to an end? Agency comes to an end. Renunciation. What is renunciation? Give up. Who gives up the agency? Agent. What is revocation? Cancellation. What is revocation? When agency is irrevocable. In the following cases, the principal cannot revoke the what? Agency. What is the first one? Agency coupled with what? Interest. Coupled with what? Revocable or irrevocable? Irrevocable. When agent has incurred what liability? Personal liability. What liability? What liability? Personal liability. Or when the authority has been partly exercised by whom? Agent. What exercised by the agent? Partly exercised by the agent. Who cannot revoke it? Principal cannot revoke it. They may ask question based on this as well. Clear with this? Yes or no? See, most of the question they ask out of Contract Act is what? Practical question. What question? Let's come to the practical question. Everybody concentrate. We should solve these questions in next 10 minutes. Listen, everybody. I want everyone to concentrate and answer my question. Let's start. What is the first one? Ram, employer in Mumbai, promised to pay 8,000 per month to his wife Sunita. She is living in Delhi and receiving information that she has become unfaithful to him. Ram stopped payment of 8,000 to Sunita. Sunita approaches to file a case against Ram. Can she file a case? No. If she file a case, will she succeed? No. Why? Because there is no intention to create what relationship? Legal relationship. It's a domestic agreement. This is similar to which case law? Mrs. Balfour versus Mr. Balfour. Remember, he made a promise to pay her 30 pounds every month. Later, he refused to pay. Enforceable, not enforceable? Not enforceable. Next one, when a contract becomes void. When it becomes void? When it is impossible to perform. When it becomes what? Impossible to perform. Or if it depends upon the happening of an event. And if the event doesn't happen, the contract becomes what? Void. Contingencies. And what is void contract? A contract which ceases to be enforceable. Ceases to be what? Becomes void when it ceases to be enforceable. Next one, offer. In a pandemic of COVID-19, a drug company made an offer by advertisement, a reward of 10,000 to anyone suffering from COVID after using their drug in a what manner? Prescribed manner. Mrs. Romila, having taken the drug as per the prescription, could not be cured. Can she claim compensation? Yes, this is what offer? General offer. What offer? This case is similar to which case law? Carlyle versus Carbolic Smoke Ball Company Limited case law. Correct, right? Next one. Next one. Concentrate. State the various ways in which an offer lapses. What lapses? Offer lapses. Lapse of offer by revocation, by rejection, by not fulfilling the condition precedent. Clear? Next one. A invites B to stay with him during the winter vacation at his residence. B accepts the invitation and informs A accordingly. When B reaches A's house, he finds it locked and he has to stay in the hotel. Can B claim damages? No. Social invitation. What invitation? Social invitation does not create what relationship? Legal relationship. What relationship? Next one, Amit acceptance. Amit's son absconded. Who is absconded? He sent Suresh, his servant, in search of the what? Boy. When Suresh had left, Amit, by handbills, offered to pay 5,001 to anyone, 5,000 to anyone, finding his what? Son. Suresh found the son and after coming to know about the offer, claimed the what? Amount. Examine the validity of the claim raised by what? Suresh. Can he claim the amount? No, because when he found the son, he was not aware about the what? Offer. This is similar to Lalman Shukla versus what case? Gauri Dutt case. Which case? Gauri Dutt case. Next one, flaws in a contract. Mention the main flaws in a what? Contract. Flaws in the capacity and flaws in the consent. Incompetent to contract. Trajan, a minor fraudulently overstate his age and take delivery of motor car after executing what note? Promissory note. Is the contract valid or void? Void. And the principle of estoppel not applicable to whom? Minor, even though he misstated his what? Age. Fraud. The government has notified an order under an appropriate statute in a month of September 2022 that no one shall buy or sell a particular explosive chemical except under the license obtained by the specified authority. Tarun applied in October 2022 and has obtained a license to buy it and was keenly looking for the person who had license to sell it. Riju, who has no license to sell, represents to Tarun that he has a license to sell and induces Tarun to what? Enter into a contract for the sale of what? Certain quantity of explosive chemical. On January, Tarun pays Riju how much? 50,000 earnest money. After a few days, Tarun learns through one of the friends that Riju has no license to what? Sell. Tarun gives a call to Riju to find the truth. Richu convinces Tarun that he shall obtain the license within the what time? Reasonable time. Before due date of delivery, but fail to obtain it. Can Tarun recover the advance payment paid to Richu? Yes, because there is a fraud, the contract is voidable, he can cancel it, and once the contract is cancelled, whatever the benefit received by the parties must be what? Restored back. Must be what? Clear with the section number क्या है 17 section number 17 next one distinguish between the fraud and misrepresentation fraud and what misrepresentation innocent misrepresentation nothing but misrepresentation next one agreement without consideration valid or void are there any exception yes what is the first exception agreement out of what natural love and affection. This is the example for what? Natural love and affection. Read the example or read the question. Arun, a husband, enters into a registered agreement with whom? Wife, Radha. Registered agreement out of natural love and affection. Enforceable, not enforceable. Enforceable, even though there is no what? Consideration. There is no what? Next one, privity of contract. Malti is the daughter of Harish, who has divided all the assets among the two sons, Dhruv and Tarun, with the condition that some provision must be made for the marriage of what? Malti. Later, the brother refuses to contribute towards the marriage of Malti on the pretext that there is an absence of privity of contract between Malti and the two brothers. Will Malti succeed? Discuss as per the provisions of Indian Contract Act. Will she succeed? Yes, family arrangement. What arrangement? Family arrangement or settlement. If they are in writing, any member of the family can enforce the contract. A, who is indebted to B, sells his property to C, and the C, the purchaser of the property, promises to pay up the debt to whom? B. Debt to whom? C fails to pay. Decide whether B can sue? No, because there is no what? Contractual relationship. What relationship? X, the father of boy of a marriageable age, and Y, the father of a girl who has to be married to boy, agreed that each of them shall pay a sum of money to the boy who has to take up the new responsibility of married life. After demise of both the contracting parties, the boy sued the executor of his father-in-law upon the agreement between his father-in-law and his father whether the suit of the boy is maintainable. Yes, it's for whose benefit? Son-in-law's benefit. Can you succeed? Okay. So in this case, the court has held that in this case the court has held that he will not succeed. However, see if it is a marriage contract, what contract? If a father makes a contract on behalf of a daughter with the other person for the marriage, now who can enforce the contract? Even daughter can enforce the contract. But in this case, who cannot enforce it? The Mr. X cannot enforce it. Not Mr. X. Who is the person? The boy, the husband cannot enforce the contract. Why? Because he is not the party to the contract. There is no privity of contract. There is no what? Privity of contract. Performance of contract. There are three promisers, X and Y and Z. Who should perform this contract? All of them during their joint lives. In case of death of any one of them, Who should perform the contract? Remaining along with what representative? Legal representative. What if one of the person is compelled to pay the whole amount? In that situation, what he can do? He can compel whom? Other promisor to perform. He can recover the money from which promisors? Other promisors. What promisors? Correct, right? Uh, we have few more questions. Impossibility of performance. Make sure you guys solve all these questions, okay? Bailment, agency. This question is important. Can you guys read this question? Agency. Rishi purchased two life insurance policies with a premium payable quarterly from ABC Insurance Company. When the fifth premium becomes due, the agent of insurer met with the insured and took a bearer check towards the premium payable by the insured in respect of the policies. The agent encashed the check immediately, but the amount of the premium was not deposited by the agent for another 4 months. In the meanwhile, the insured met with a fatal accident and died. The claim of the widow of the insured was repudiated by the insurer on the ground that the policies had lapsed on the account of non-payment of the premium. Whether the claim of the widow may be recovered from the insurer decide. The present case is similar to which case? Arshad G. Shah versus what? LIC. In this case, Supreme Court held that agent had no express authority to receive the what? Premium on behalf of the corporation. In his letter of appointment, there was a condition expressly prohibiting him from what? Collecting the premium. Nor could it be said that he had an impaired authority to what? Collect the premium. Correct, right. Therefore, no case had been set up by the complainant before the state commission, but the corporation by its conduct had induced whom? Policyholder, including the insured, to believe that agents were authorized to receive the premium. Correct, right. Hence, who is not responsible? Corporation is not responsible. Who is not responsible? Corporation is not responsible. However, when it may be given on the what grounds? Humanitarian grounds. Usually, what happens is that these insurance agents can they collect premium? No, they can only execute the insurance contract. They don't have a right to collect the premium. If they collect the premium and they misappropriate it, is the company responsible? Not responsible. Not responsible because they don't have a right to collect the premium. They're not the agents of the insurance company. Agents of what company? Insurance company. These are the practical question. What question? Practical questions. Clear with this? Which they may ask in the examination based on the Indian Contract Act 1872. Okay? So we'll start with Sale of Goods Act. What act? Sale of Goods Act. So Sale of Goods Act 1930. Let's solve the previous year questions of Sale of Goods Act 1930. Question number one. With respect to the goods, they may ask you to write what is goods. What is goods? All kinds of what property? Movable property other than actionable claim and money includes what? Stock, shares, growing crops, grass, things attached to or forming part of the what? Land which are agreed to be severed before the sale or under the contract of sale. They are called as what? Goods. Called as what? Goods. Next one. Goods perishing before sale, but after what? Agreement to sell. If the goods perishes before sale, but after agreement to sell, is the agreement valid or not valid? Not valid. Agreement is void. Because ownership is not transferred, right? Ownership is transferred only on what? Sale. If the goods are destroyed without the fault of seller or buyer before the ownership transfers, what happens to the contract? Agreement becomes void. What becomes void? Agreement becomes void. Clear with this? With a view to boosting the sales, Hanuman Automobile sales a motor car to sells a motor car to whom Mr. A on a trial basis for a period of how many days? 3 days, with a condition that if Mr. A is not satisfied with the performance of the car, he can return back the car. However, the car was destroyed in a fire accident at the place Mr. A before the expiry of how many days? 3 days. Is the ownership transferred or not transferred? Not transferred. Then risk is also not transferred. Agreement becomes void. Agreement becomes what? Void. Yes or no? Next one. Conditions as Warranty. Section number 13 provides a situation where condition sink to the level of what? Warranty. Or a condition becomes warranty. What is a condition? A stipulation which is essential to what purpose? Main purpose is called as what? Condition. A breach of condition gives how many remedies? Two remedies. Resign and claim the what? Damages. Claim the what? Damages. So what buyer can do in case of breach of condition? He can cancel and file a suit for what? Damages. But however, there are few cases where a breach of condition becomes what? Breach of warranty. What is the first one? Buyer waives the performance of the condition. Or second one, he treats the breach of condition as what? Breach of warranty, where the contract is what? Indivisible, and buyer has what? Accepted the goods. Accepted the what? Goods. And the seller is excused by the law. Excused by the what? From fulfilling the what? Any condition or warranty. Condition or what? In all these cases, what cases? All these cases, a condition becomes what? Warranty. What becomes warranty? Conditions becomes the warranty. What is the first situation? Buyer waives the condition. Second one, buyer treat the breach of condition as breach of warranty. Third one, contract is indivisible and the buyer has accepted the goods. And the last one, seller is excused by the law from fulfilling any condition or warranties. In these cases, a breach of condition becomes what? Breach of warranty. Means you can only claim the compensation. Next one, we'll discuss the practical question. Condition as to what? Title. What does it say? When a person sells the goods, he should be the owner, means he shall have a right to sell the goods. And when he agrees to sell the goods, he shall have a right to sell the goods when the property passes from whom? Seller to the buyer. Seller to whom? Without having ownership, if you sell the goods, is it a breach of condition? Yes. Then what buyer can do? Cancel and sue for damages. Sue for what? Example number two, question number two. Let's read question number two. Jolly bought a second-hand car from Yogesh for how much? 85,000 and paid for it. After Jolly had used the car for 6 months, he was deprived of it because Yogesh had no title to it. Can Jolly recover the price of the car from Yogesh? Yes, because there was a breach of what? Condition. Condition as to what? Title. Condition as to what? Next one, quality and fitness. Quality and what? Fitness, section number 16. Correct, right? A inspect a hot water bottle at a chemist shop and inquires whether it will be stand boiling water. A is told that it will stand what water? Hot water, but not the what water? Boiling water. He is selling that it stands the hot water. A puts the hot water, it is burst, and the buyer is injured. Is the seller responsible or responsible? Responsible. Clear? Because buyer made the purpose for which he need the goods. Relies upon whose skill and judgment? Seller's skill and judgment. Now it becomes whose duty? Seller's duty to supply the goods suitable for whose purpose? Buyer purpose. Otherwise, who is liable to pay compensation? Seller. To whom? Buyer. What is doctrine of caveat emptor? What is caveat? Let the buyer be aware. Are there any exception? Yes, write the exception. Now, A goes to the B shop and purchases what saree? Silk saree. Thinking that it was what saree? Banarasi silk. It is whose fault? Buyer fault. Can he make the seller responsible for this? No. Contract is valid or not valid? Valid. Let the buyer be aware. Specific goods to be put into what state? Deliverable state. Transfer of ownership, specific goods, but not in what state? Deliverable state. When the ownership is transferred, when the goods are put into what state? Deliverable state. What state? A certain quantity of oil was bought. The oil was to be filled into barrels by the seller and then taken away by whom? Buyer. Some barrels were filled in the presence of whom? Buyer. Whether what is transferred? Ownership is transferred. But before the remainders could be filled, the fire broke out and the entire quantity of the oil was destroyed. Now, who is responsible for whatever already separated or filled in the drums? Buyer is responsible. For the remaining, who is responsible? Seller. Clear? Next one. Goods sent on what basis? Approval basis. When the ownership is transferred, when the approval is given. Can be either expressed or implied. What is expressed? When he assent to it. What is implied? When he retains the goods without rejection beyond the prescribed time, no prescribed time, with a beyond the reasonable time. What time? or if he does something to adopt the transaction, like he pledges it, uses it, or consumes it, or he resell it to somebody, all this amounts to what? Implied acceptance. What acceptance? Implied acceptance. Goods sent on what basis? Approval basis. What basis? अरे बोलो what basis? Amar delivered some cotton bales to Bharat on a sale or return basis. Bharat then delivers the same goods to Chandan, and Chandan further delivers it to whom? Through on the same terms and conditions, and which Amar delivers to Bharat. Before Dhruv could give his acceptance, goods are suddenly destroyed by what? Fire. Who is to bear the loss under these circumstances? Right. Amar delivers some cotton bills to whom? Bharat on a sale or return basis. Bharat then delivers it to whom? Chandan. The moment Bharat delivers to Chandan, it means what is transferred? Ownership is transferred from Amar to Bharat. Then Chandan delivers it to whom? Dhruv on the same terms and conditions on which Amar delivers it to whom? Bharat. Before Dhruv could give his acceptance, goods are what? Suddenly destroyed by fire. Who is supposed to bear the loss under these circumstances? Chandan is the one who is supposed to bear the what? Losses. Correct, right? Answer is A means here Anand, B means Bharat, C means what? Chandan. Ankur agreed to sell horse to Iswar on the condition that Iswar will keep the horse for a 10 days on a trial basis and have the option to return the horse within the what period? Stipulated period, if he finds the horse suitable. However, the horse died on the third day itself. Now, who is responsible? Seller or buyer? Seller. Because what is not transferred? Ownership is not transferred. Risk always goes with what? Ownership. Are there any exception? Yes. Delayed delivery or fault of the seller or buyer. If the fault of seller or buyer, then who is responsible? Party under fault will be responsible. Can you write the theoretical provision? Section number 26. Yes or no? Next one, sale by non-owner. What owner? Same like pledge by non-owner. Nemo, dad, quad, non-avid. No one can give what he has not got. What he has what? Not got. Are there any exception? Yes. There are what? Exception. Sale by mercantile agent. What agent? Mercantile agent. Owner. Person in possession under what contract? Voidable contract. Possession after sale. Buyer in possession. Estoppel. Sale by what seller? Unpaid seller. Sale by person under what laws? Other laws like pledge, official receiver, or liquidator in case of company. These are the cases where who can sell it? Non-owner can sell it. Example number two, question number two. Mohit finds a ring of Sharda and sell it to the third person. Prachi, who purchases it for a value and in good faith. Whether Sharda can file a suit to recover the ring. Advise with the what? Valid reason, a cogent reasons. Mohit finds the ring award, Sharda, and sells it to whom? Third person. Can she sell it? Can she sell it? No. When she can sell it? Does tell me, does did he had a right ownership to sell it? Did he then is the will the buyer become the owner? No, because the nemo that quad non have it provides that no one can give a ownership or no one can give a better title than what he has or what he possesses. He is not the owner, buyer will not become the owner. Will not become the owner, buyer will not become the owner. Sale by joint owner, sale by what owner? Joint owner. Ah, that he can. Aman, Raman, and Chaman were joint owners of a truck. Can a joint owner sell it having possession? Yes. Is it valid? Yes, valid. One of the exception. Payment and delivery are what condition? Concurrent at the same time, unless the parties agrees. Otherwise, write short note on delivery of goods. What is delivery? Voluntary transfer of possession of goods by one person to another person. There are how many types of delivery of goods? Three types. Actual delivery, symbolic delivery, constructive delivery. Yes or no? Next one, unpaid seller. What seller? Who is unpaid seller? Who has not been paid or tendered the whole of the price of the goods sold, or who had received a bill of exchange or any other negotiable instrument as a conditional payment. What payment? But which is subsequently what? Dishonored. Subsequently what? Dishonored. Then he is called as what seller? Unpaid seller, he has not received the payment or received only a part payment or received a check which is dishonored. Then is called as what seller? Unpaid seller. Rights of unpaid seller, lien, stoppage in transit, resale, withhold the delivery of goods. Correct, right? We discussed all these things now. Yes or no? Next one. This question is important. They asked this question in the previous examination. A sells 2 tons of oil to B and sends 1 ton of oil by what? Road, and remaining 1 ton of oil by what? Ship. B receives a delivery of what? 1 ton of oil. Once he receives the goods, he loses the right of lien or stoppage in transit. Correct, right? However, before he receives the delivery sent by ship, he becomes what? Insolvent. Who becomes insolvent? Buyer. A buyer becomes insolvent. Who has the right of stoppage in transit? Seller. Even though part delivery is done on the remaining part of the goods, the seller can exercise the what? Right of stoppage in transit. Stoppage in what? And he can take back the possession of the goods. Auction sale. What sale? You know what is auction sale, right? What is auction sale? Where the sale happens to the what? Bidding. Right? And if there are goods are sold in lot, each lot is considered as what contract? Separate contract. What contract? And when the auction is complete, on the fall of hammer. Fall of what? Correct, right? Seller right to what? Bid. Can a seller bid his own goods? Can a seller bid for his own goods? Yes. If it is intimated to whom? Bidders. If it was not intimated, if the right to bid for his own goods is not reserved, then he cannot bid for his own goods. Reserve price. What price? What price? What is reserve price? The minimum price below which the goods will not be sold. That is called as what price? Reserve price. What is pretended bidding? If a person pretends to bid to buy the goods, but if he did not have the intention to buy, it is called as what? Pretended bidding. What bidding? What bidding? Pretended bidding. Clear with this? So these are the concepts of what? Sale of Goods Act. Which Act? Sale of Goods Act. With the help of the short notes, revise, listen everybody. With the help of the short notes, go through the concepts and try to answer these questions. Clear? Thus, you can write question answers in the examination. Clear with this? Most of the question they ask out of this chapter will be practical question. What question? Practical question. Clear with this? Last exam, they asked 2 questions out of this chapter. They may ask 1 or 2 questions again in the upcoming examination as well. Clear with this? Then we have last chapter. What chapter? Last chapter. What is the last chapter? Negotiable Instrument Act 1881. 1881. Lesson number 18. Negotiable Instrument Act. Which act? Negotiable Instrument Act. What is negotiable? Transferable. What are instruments? A written document. What document? Written document which are transferable from one person to another person. There are 3 important negotiable instruments. What are they? Promissory note, bill of exchange, check. First one, holder. You know who is holder? Holder is a person who is entitled to the possession of the instrument. What of instrument? Possession of the instrument in his own name and entitled to right the benefit of the instrument. What of instrument? Benefit of the instrument. Then he is called as what? Holder. Who is holder in due course? One who receives the instrument acting in what faith? Good faith before the maturity for a valuable consideration. What consideration? From a person having what title? Defective title. He gets the better title. Correct, right? Anyone who receives the instrument before maturity for valuable consideration, acting in what faith? He gets a what title? Better title. What title? Better title. That is called as what? Holder in due course. What in due course? They may ask you to explain the meaning of holder and holder in due course. Next one. Uh, Whether a person who has obtained the possession of an instrument by theft, will he be called as a holder in due course or holder? No. Because who is holder? The one who has the right possession of the instrument in his own name. What name? And he has a right to receive the benefit of the instrument or to recover the amount mentioned in the instrument. Then he is called as what? Holder. Called as what? Holder. Next one, what is ambiguous instrument? An instrument can be treated either as a bill or as a what? Promissory note. It is called as what? Ambiguous instrument. What instrument? There is one question based on what? Ambiguous instrument. What instrument? Ambiguous instrument. Then we have inchoate stamped instrument. Remember, incomplete instrument. When a person signs and delivers a stamped instrument, it is called as what? Incomplete instrument or inchoate instrument. When he delivers it, he impliedly give a right to whom? The recipient to fill the amount and make it complete. Correct, right? The holder of the instrument can fill the amount which was agreed to be paid or intended to be paid by whom? Paid by the one who delivers it, one who are delivers it. So if we fill more than what was intended to be paid by the drawer, we cannot recover the more amount. But however, if it is delivered to holder in due course, what in due course? He can recover the amount, any amount mentioned in the instrument up to what value? Stamp value. What value? And stamp duty. Whatever stamp duty has been paid. We discussed many case laws for this. Yes or no? Holder in due course, ambiguous instrument, inchoate instrument, inland instrument, foreign instrument. Remember, inland instrument, foreign instrument. Are yes or no? Next one, capacity to make promissory note. Can a minor make a promissory note? Can he be a payee? Payee means one who receives the payment. Can he receive the payment? Yes, he can be a payee, he can be an endorsee, but he cannot be a drawer. Cannot be a what? Drawer. He cannot incur any liabilities. Who cannot incur any liabilities? A minor cannot incur any what? Liabilities. Incur any what? Liability of the prior parties to render the what? To holder in due course. What in due course? Are they responsible? Not responsible? Responsible. There is one question based on what? Liability of the prior parties to the holder in due course. Discharge of endorser's liability. Whose liability? Who is endorser? The one who does the end. What is endorsement? Writing at the back of the instrument or signing at the back or the face or any of the paper attached to it with the intent to convey the title. Convey the what? Title. That is called as what? Endorsement. Called as what? Called as the endorsement. X is the holder of a bill of exchange made payable to the order of B, which contains the following endorsement in blank. First endorsement B, second endorsement C, third one D, fourth one E. X strikeouts whose name? E's name. Whose name? E's name. Uh, E without a strikeout. E's without E's consent. The endorsement by whom? C and D. C and what? D. So without whose consent? Without E's consent, he cancelled whose endorsement? C and D. C. If X has an instrument, he can go against E. E against whom? D. E against whom? C. But what Mr. X has done? He cancelled whose name? C and D's name. Means he cancelled whose eventual remedy? E's eventual remedy. Because he cancelled E's eventual remedy. Who is discharged now? E is also discharged. Who is discharged? Because if you file a case against E, he will go against whom? D. D against whom? C. But as a holder, you cancel the remedy of Mr. E against D and C without his consent. Now who is discharged? E is also discharged. Who is also discharged? E is also discharged. Because you cancelled my eventual remedy. What remedy? Eventual remedy. Answers are also given. Please go through that. Negotiable instrument made without consideration. Valid or void? Negotiable instrument made without consideration. Valid or void? Void. Enforceable, not enforceable? Not enforceable. You cannot recover the money. Instrument endorsed in blank. If you endorse an instrument in blank, it is called as what endorsement? Blank endorsement. What endorsement? Correct, right. It also becomes a bearer instrument. What instrument? Bearer instrument. What is sans recourse endorsement? Without recourse, without any what? Recourse. If a person does sans recourse endorsement, he is not responsible in case of what? Default. In case of what? That is called as sans recourse endorsement. Instrument obtained by what means? Unlawful means. What means? Or for unlawful consideration. Valid or not valid? Not valid. This question is important. Mark question number 3 as important. Distinguish between negotiability and assignment. Negotiability happens as per the Negotiable Instrument Act 1881. There are two ways of negotiation. First one is by what? Delivery. Second one is by what? Endorsement and delivery. Assignment is as per which act? Transfer of Property Act, which requires a separate contract. What contract? And there is also requirement of payment of stamp duty. Negotiation, there is no requirement of separate document, plus there is no requirement of what? Payment of stamp duty. Payment of what duty? And there is a concept of holder in due course in case of negotiation. Means if a person having defective title negotiate the instrument, who gets better title? Holder in due course gets the better title. But in case of assignment, there is no concept of what title? Better title. There is no concept of holder in due course. Holder in what? Are a holder in what? Due course. Presentment for payment within what time? Prescribed time. What time? Prescribed time. Rate of interest. What is the rate of interest in case of disorder of instrument? Specified, right? Otherwise, 18% per annum. 18% per what? Annum. Discharge from liability. Discharge from what? Liability. When a person is discharged from his liability. Cases, cancellation of instrument, release, discharge of which party? Secondary party. We just now discussed. If you discharge one of the secondary party, the intermediary is also discharged. Operation of law, that is insolvency of the debtor by allowing drawing more than how many years to accept? 48 hours. The drawer, sorry, holder of the instrument should not give more than how many years to accept it? 48 hours to accept it. Or in case of material alteration, check if a person does not present the check within what time? Reasonable time. What time? And if the whole drawer of a check suffers the loss, who is discharged? Drawer is discharged. Disorder of check is important. Section number 138. Section number what? 138 is important. Also, this material alteration. What alteration? Material alteration. Uh, Crossing of check. Have I discussed crossing of check? This concept is also important. Crossing of what? Check. Types of crossing. Types of what? Crossing. And most important, section number 138. Disorder of check. What of check? Remember, disorder of check. Three essential. Check is presented within the prescribed time. What is the time limit? 3 months. And check returned because of insufficient balance. Third one, you have given the demand notice within 30 days from the date of dishonor, and the employer fails to make the payment within how many months? How many days? 15 days. Then you can file a complaint in the magistrate court within how many months? 1 month. How many months? 1 month. Important. And there is one more question based on what? Check. See, he has a balance of 50K, draws a check, sorry, balance of 49K, but draws a check for how much? 50K. Is it a disorder of check? Yes. Is it punishable? Not punishable? Punishable. How many years of imprisonment? 2 years. How many years? 2 years. And a fine which may extend up to how much? Twice the amount of the check. Twice the amount of the what? Check. Rights of the banker, or when banker must refuse the payment. हमने discuss किया था ना, when he may refuse the payment and when he must refuse the payment. In these cases, who should refuse the payment? Banker must refuse the payment. Go through the short notes which I have shared one, and also the material, and solve these questions. This much is sufficient for the examination. Sufficient for the what? Examination. With these, we are done with what? Negotiable Instrument Act. What Act? Negotiable Instrument Act. 3 days, 11 hours of continuous class on every day. 11, 11, and 11. Day 1, 11 hours. Day 2, 11 hours. Day 3, 11 hours of continuous 11 hours of classes on all the 3 days for a rapid revision of what? Jurisprudence, interpretation, and general laws. I hope this rapid revision is helpful to you guys to revise all the concepts which I've discussed in detail in the class. And I hope this will help you guys in your examinations as well. Okay? Yes or no? So can I ask questions now? Yes or no? Let me ask questions. I want quick answers. Let's see how effective this marathon is. Okay? Let's start. I'll ask questions now. Which article deals with right to equality? Right to equality, 14. Then freedom. Who gave Who classified the laws into law properly so called and law improperly so called? Austin. John Austin. Not Austin, John Austin. Tell me what are types of precedents? There are how many types of precedents? Original precedent, declaratory precedent, absolutely authoritative precedent, and then conditionally authoritative precedent, then persuasive precedent, then that's it. Correct, right? There are how many types of customs? What are two types? Customs without sanction, customs having sanction. Customs having sanction, how many types? What are two types? Legal customs, conventional customs. Yes or no? Tell me, what is causus omissus rule? It's a situation which where the legislature omitted to cover a specific issue which he has intended to cover. That is called as what? Causus omissus rule. And the courts, by applying the principle of equity or justice, they can fill that what? Gap, either by reading in the words or by omitting the words. That is called as what? Causus omissus rule. Correct, right? Yes or no? Tell me, what are the stages at which judicial review is done as per the Constitution of India? What are two stages? Delegation of power and exercise of what? Delegation. That is non-application of mind. Abuse of discretion. Abuse of what? Discretion. Second one, non-application of mind or acting under dictation. Or the third one, non-application of mind, acting under dictation, and the third one is what? Acting mechanically without applying the mind, without any due care. Yes or no? Yes or no? Once time starts, will it stop? It is called as what? Continuous running of time. Section number 9 of what? Limitation Act. Tell me, theft punishable, not punishable? What is theft? I DM the PCM. Extortion. If PV Sindhu, what is PV Sindhu? If any person put the other person into fear and causes him to what? Deliver any property or valuable security or anything signed and deliver, which can be convertible into what? Valuable security. What security? That's private defense, extent to causing the death of a person in case of what? Acid attack, then death, grievous hurt, then attempt to rape or unnatural lust. Correct, right? Are there any compoundable offenses? A theft of a theft for the first time, value of which does not exceed 20,000 rupees. Is it compoundable, non-compoundable? Compoundable. Correct, right? Compoundable, non-compoundable? Compoundable. Yes or no? Make sure you guys solve all the questions of the question bank and keep watching this marathon video at least once in a week or twice in a week so that you'll be in a position to cover all the topics within 10 to 15 hours. So this marathon video will be of around how many hours? Around 20, max to max 25 hours. Means 3-4 days you can cover the entire JIGL. Fast track revision. Keep a material, along with the material what? Keep watching the video so that it will become easy for you guys for the purpose of revision. And for example, you should refer the what? Class notes. What notes? Class notes, where I have given many examples. And for that, you can also refer the video recordings in the Academies app. Correct, right? There I have explained all the concepts in detail with the examples. Clear with this? Yes or no? The mission, the target is what? 80. Target is what? 80. More than 80. Is it possible? Not possible. Possible, possible, possible. Yes or no? Yes. So let's wind up. Thank you.